of list 2.
Three.
3. This is the concurrent list. Mullahs, would your lordships be kind enough, Mullahs, to hear the states as well?
The states have already filed intervention applications.
Now, 2 states have, Mullah, but there's no notice gone to anybody. I mean, it's up to you, but I can only say.
We'll consider that. We'll consider that.
Because once it is in the concurrent list, Mullahs, then states can themselves legislate. This is something that your lordship should consider and hear the state.
What we'll do is let whoever is opening the case on behalf of the petitioners open the case. Let's have in about 15 minutes what is the nature of the canvas of the proceedings that they're going to urge. So we'll have to we'll form a better view after about, say, 15 minutes of their opening their arguments.
I have some more, something more to add, my lord. I adopt what the learned senior has said. Lord, the subject, your lordships are dealing with virtually, my lord, creation of a socio-legal system, socio-legal relationship of marriage, which, my lord, I'll come to, my lord, my preliminary objection would be, my lord, the domain of the competent legislature. When the subject is in the concurrent list, we cannot rule out the possibility of one state agreeing to it, another state legislating in favor of, another state legislative against it. So therefore, in absence of the states being not joined, my lord, the petition would not be maintainable. That's one of my preliminary objection. Lord, as I mentioned yesterday, Lord, I have also filed an application, my lord, requesting that decide a question which I have formulated as a preliminary question, my lord, essentially for this reason. A, Lord, the notices were issued in January, my lord. We didn't have an occasion, my lord, thereafter matter was never heard in merits, to raise the preliminary objection whether this court can at all go into this question, or it would be essentially for the parliament, my lord, to go into that question. Second, my lord, we also, my lord, would like to point out what would be the repercussions, my lord, if the court were to take it upon itself, my lord, in the judicial forum to take this call. The sum and substance of my application would be, if I were to say in one line, the debate which is to happen with respect to the subject matter of creating, conferring a sanctity, legal recognition of a socio-legal institution, should that be the forum of this honorable court or the forum of the honorable forum of the parliament?
Mr. Solicitor, 2 responses to that.
Lord, may I
just one second, Mr. Ragbi. The nature of your preliminary objection and the tenability of your preliminary objection will really depend upon the canvas which they open up. And we say that with a due amount of reflection of mind on this. Let us see what is the canvas that they are opening up. Second, so that then we can consider your response. Second, what is really in the nature of a preliminary objection that you seek to raise is really your response to the petition on merit.
No, my lord.
So we'll hear you on that.
Lord, I'm sorry, certainly, my lordships may not preempt, my lord, my submissions on merit.
We'll hear you, of course. I mean, it can't be lost to our mind that what you're going to argue is that
I'm obliged, my lord, your lordship will hear me, my lord.
That it's essentially in the domain
Kindly allow me to clarify.
Kindly enter into it. So we'll hear you on that at a subsequent stage when you are responding to the arguments. Second, once we have some picture in the first 15 minutes or maybe half an hour on what is the canvas they are arguing, we may have a response to them on what is the canvas that we want to open up in this matter. But that's after we hear them, because
Lord, may I say, let me make my submission.
To tell them that, well, this is what we want to be, which we want to go into, would be really to preempt their submissions on what they want us to go into it. In all probability, for instance, they may say that this is so far and no further.
Personal law, there are also issues of personal law, adoption, succession, several issues that arise out of this, Mullahs. And that's the canvas that your lordship should be looking at.
Only one more thing. I'm after my lord, Mr. Sibyl comes.
This is the canvas. We want to view how it is being opened up.
Yes.
And whether it's the whole canvas to be opened up, not to be.
That's correct. That's
they're not that we are not.
No, your lordship. I'm just the caveat that I'm just putting.
You're right. Yes, you're right.
There are other very complex issues Whether your lordships would like to go into that, not go into that, once we know, then we'll be able to address your lordships.
That's exactly what we thought we'll. That's present to our mind.
Can I conclude, my lord? Can I
Yeah.
complete my request?
Yeah.
My lord, I'm sorry, my lord, my lords. Slightly, my lord, preempted my request. First of all, I'm making it very clear. My preliminary my lord, objections are not my objections on the merits. If merits were to be gone into, there are separate set of arguments. These are not, my lord, these are only for deciding which forum would adjudicate upon and which forum would be the suitable forum and constitutionally the only permissible forum where this debate can take place. So by the very nature of the objection, it must, in my respectful submission, be heard first. While arguing my preliminary objection, I'll not raise any submissions on the merits of the case. I'm, my lord, very, very clear about it. And, my lord, therefore, my lord, your
So,
lordship,
Mr. Solicitor, we'll reserve, whether to hear you on the preliminary objection at this stage after they have opened up, just for about 15 to 20
my lord,
minutes. So that then we can-
then your lordships may do one thing, my lord. That's the another request. My lord, let them give, my lord, their, my lord, suggest whatever submissions they want, overview, confined to, my lord, what my preliminary objection is. My lord, I can't be
That we will not do
non-suit.
that. Certainly
my lord,
not. We'll not do
I have to
anything.
open my case.
My lord, I'm sorry, my lord. My lord, I'm sorry.
I'm sorry, Mr. Solicitor. We are in charge. We will hear
Well,
Mr.
I have
I'm
to
sorry,
open
my lord.
my
Kindly
case.
last minute, my lord,
Let me
last.
Mr. Solicitor, we'll hear you later.
Yeah.
Yes, Mr.
My lord,
Roy.
only a minute, my lord, only a minute.
No.
My lord, your lordships may give me a minute.
Dictate to us how we will conduct the proceedings.
No, I'm not, my lord. I am
I'm not
earnestly
allowed that
requesting.
in my court.
My lord, I am earnestly requesting. I would never do that. Your lordship knows, my lord.
Yes.
My lord, this is a matter, my lord, too sensitive an issue,
Of course,
where, my lord,
yeah.
your lordships would examine the preliminary submissions and, my lord, then give me some time. We may have to consider what would be the stand of the government, my
Sir,
lord, in further participation in this debate.
so trust us to have a broader perspective of everything.
Well, I fully trust, my lord. There is no question
Therefore,
of lack of trust.
we want to understand from them what they want to argue.
My lord, then, my lord, your lordships may give me time, my lord, to consider to what extent the government would like to participate in this.
Anything but adjournment, and I think anything but an adjournment.
No, I understand, my lord, your lordship's anxiety, my lord, I understand. I share that.
Solicitor, are you saying that you don't want to participate? No,
Lord,
very
my lord,
strange
I am
for you
only
to
saying,
participate. It's a prerogative you have.
my lord, Lord,
Uh,
I'll not
but
go that
can
far,
you-
my lord.
No, Mr. Solicitor, that, let me say that. It didn't look nice. When you say that we will see whether we participate or not.
No, my lord, I'll take instructions. I didn't say I'll not participate.
Instructions are here with this constitution.
My lord, the instructions on the question whether which forum should debate and discuss this subject.
That's a very important situation itself. That's the main this thing, whether the court can go into it or whether only parliament will legislation issue like this.
Lord, your lordships would
Fundamental
examine, Lord, kindly give me 2 more minutes. Lord, this is not an issue which can be debated, Lord, by 5 individuals very learned on that side, 5 individuals on this side, 5 very brilliant minds on the court, no doubt about it. None of us knows what are the views of, my lord, a farmer in South India, a businessman in, my lord, Northeast. Lord, these will have to be, my lord, this will have social and other ramifications, my lord.
Yes, of course. We'll consider that. We'll certainly have that in
My lord,
mind.
your lordships, I'm sure would consider the request. Only request is kindly consider that first.
No, we'll allow them to open the case so that we have
My lord,
an
then your
idea on
lordships
what they
may,
are.
my lord, rule on that.
may I-
That's my prayer, my lord.
May
That's
I
my
submit,
prayer.
my lord?
Yes.
A short preface first.
Statement of state, my lord, on
Yes.
behalf of state of Madhya Pradesh, which your lordship was kind enough to direct. it.
Sir, we'll hear you. There's no
It is
difference.
not
Your
for
lordship may hear any
intervention, my lord.
state. We have no objection. Your lordship may hear any state.
No, not
But just as a
intervention, I'm
preface,
saying
No, you should have
everything
joined
which the
every
solicitor
state
has
as a.
said does not, my lord, hinge on maintainability of a petition under 32 by an individual who complains that his fundamental rights are being restricted in some form. I have a right to approach this court. This will be a defense, whether your lordship will leave it to the legislative forum or the courts forum. There is no question of saying, my lord, that I should answer that first. I will open my case. They will raise a defense. Please don't touch it. Throw it away. Your lordship do it all the time. Matter of executive policy, we won't touch it. He will say whatever he has to say. But I have a right to file a 32. I have a right to be heard. My grievance may be right, may be wrong. Your lordship will deal with it. And your lordship will deal with their responses about, my lord, this, that, or the other. When it comes, it's not a case of 7-11. that, my lord, a suit is barred by operation of law. That is a preliminary objection. This can't be a preliminary objection that your 32 is there, but the impact of 32 will be this or that.
No, it's
That impact
maintainability
can
is
never be a part,
preliminary
Lord,
objection.
of a preliminary objection. That be a defense. That don't touch it. This is too overbroad. This, that. They will say all that, my lord. So now, my lord, let me open my case.
Yes.
Well, only one aspect, my lord, and
Please now.
Yes.
ultimately
Allow
it's the
us to
lordship's prerogative. But I should not, my lord, be, my lord, told after, my lord, generations after generation, we did not bring this to your lordship's notice. In Special Marriage Act as well as in Hindu Marriage Act, every state have separate rules.
Please.
That makes more, my lord, case for calling all the states and hearing them. Your lordships have, my lord, partial view from both sides.
Only one.
He is very clear about his view. I may be very clear about my view, but none of us represents views of the nation.
Milord,
That's my preliminary
You are-
objective.
Milord, the Solicitor General is aware of all the persons that we are talking of fundamental rights. Fundamental rights, by their very nature, are a limitation on the legislative power of the state. Your Lordship need not defer to
I am
Parliament.
not for a second
now-
saying
If it is a fundamental right,
is not
Milord,
there.
and if it
Who
is,
should protect the fundamental
if it is
right?
a
Whether by
status-
parliamentary law?
All right. What
or
we
by
do is,
Can I- let us
fair
start,
enough.
fellas.
Milord, if it is a status confined to,
We'd like
me
to
open my case.
yes. You can tell us.
Yes,
about
let me
15
open my
What
case.
is the canvas of the case?
So, my lord, in a very, very narrow conspectus, my lord, we are persons, my lord, who are of the same sex. We have, my lord, according to us, the same rights under the constitution as the heterosexual group of the society. Your lordships have held so. I don't need to reinvent the wheel. That we have exactly the same rights as our brethren of the heterosexual group of society, which is the majority. We are a minority. The only stumbling block on our equal rights, equal opportunities, equal dignity, equal fraternity was, my lord, 377. By virtue of 377, our actions were subject to criminality. Because it was criminality, my lord, it could not be equal in all measures of the heterosexual group. Criminality is now gone. The unnatural part or the order of nature under 377 is now effaced from our statute book. And therefore, our rights being equal in all forms, which are, my lord, reflected from Puttu Swami, Navtej, my lord, the judgments of this court on the right to marry a person of your own choice, Shafeen and all that, which I will show. If our rights are identical as held by the state, then we want to enjoy the full panoply of our rights under 14, 15, 19 and 21 to lead a dignified life, not mere existence like your lordship said in Francis Corali Bulletin 40 years ago. To lead a life to our fullest extent with dignity, privacy in our home, and, my lord, without taint or stigma in public places. And therefore, we cherish and desire the same institution between two people as is available to the others, which is, my lord, the concept of marriage, the concept of family, because marriage and family is respected in our society. We don't, my lord, today, my lord, laws have now, my lord, progressed. In the Domestic Violence Act, even live-ins, my lord, are allowed. That is recognized by the court. Your lordship recognize it by even giving, my lord, property, money, inheritance, etc. So there is no reason why, once our rights are identical and same as held by your lordships, my lord. And that has been the development, my lord, in the US and other nations. I have made a one-page chart which I'll show to your lordship. Therefore, my lord, we seek a declaration. Because we have to be concrete. What do we want from the court? We seek a declaration that we have a right to, my lord, get married. That right, my lord, will be recognized by the state and would be registrable under the Special Marriage Act and other acts. But as far as I am concerned, my lord, my brief is to say that we want a declaration that we have a right to marriage and that marriage will be recognized by the state by virtue of the imprimatur of this court. And once that happens, the society will recognize us. Because even after 377, my lord, there is a stigma. If two people walk hand in hand in a park, my lord, or in a hotel or in a mall, they are still stigmatized in public. That stigma will only go after the imprimatur of this court that they are entitled to get married, and the state shall recognize it. And once the state recognizes it, it can also be registered. And that will be full and final assimilation of this minuscule group, my lord, into
Now, Mr. Rohde, assuming that you seek a declaration from the court
yes,
that queer people belonging to the queer community,
yes,
same-sex couples,
have a right to it.
have a right to marry, and therefore the state must recognize the
My
marriage
lord.
between these two. Now, what is the next step? Are you therefore saying that the Special Marriage Act already recognizes that right inherent in it?
Well,
a matter
my
of
lord,
an interpretative device or an
by an
interpretative
interpretive, my lord, I don't want it to be quashed or anything.
Right.
By an interpretative device, in one line, if I was to say, the provisions, my lord, of the Special Marriage Act made in 1954. Today, my lord, we are now 70 years down. There is a lot of evolution. As I said, my lord, livings, etc., have now come in. I want to say, my lord, that your lordships will broadly read spouse in place of man and women, or husband and wife. And that is it. And if I may show, my lord, a classic example of the definition of marriage in Black's dictionary, which I will show to your lordship, in 1968, said, my lord, it's a union of a man and woman. But when the definition came in 2019, it says, my lord, a union of two persons. So concept of marriage has changed over last 100, 200 years. We had concepts of, my lord, group marriages. We had very different concepts. We had concepts of child marriage. We had concepts of, my lord, temporary marriages. We had concept that, my lord, prior to the Hindu Code Bill introduced after by Pandit Nehru, my lord, in 1950, a person could marry any number of times. That, my lord, also changed. Hindu Code Bill, my lord, was not accepted. There are a lot of protests to this new avatar of the Hindu Marriage Act. It was not accepted. And Dr. Ambedkar had to resign. Then came the evolution of Hindu Marriage Act. Now in Hindu Marriage Act itself, my lord, in 2005, the rights which were restricted of women, starting from the Women's Right to Inheritance Property Act in 1937, all that has now changed, my lord. And full rights are available in 2005. So, my lord, Constitution is a living document. The preamble says, my lord, equality, fraternity. And I will read passages of, my lord, the Chief Justice, my lord, judgment, my lord, in Navtej, in Puttaswamy, in Shafin, in Deepika, and Justice Kaul, my lord, also referring to it. This is the thread. If this is the thread of the Constitution, equality, fraternity, justice to all, today we are a part of the all. The only thing which was stumbling, my lord, was that criminality. That is now gone. If we are a part of all.
So really, your analysis is two-step. One, the declaration of marriage as a fundamental right,
My lord,
as being implicit in the constitutional guarantees,
my lord,
14, 19, and 21.
No, as interpreted by your lordships, my lord, in Puttaswamy,
Yes, of
Navtej,
course.
basically.
And then step two, the second limb of your submission, that this also can find recognition by a reading,
My lord,
an appropriate
my lord,
reading of the
my lord,
Special Marriage Act.
My lord.
So you're not going into the broader issue of personal law and other things, we take it. Right?
No, my lord, I am not.
Right.
And I am not also touching any personal law of Muslims, etc., my lord. Somebody may raise an issue, I am not. Hindu Marriage Act, yes, but basic first will be Special Marriage Act. And your lordship knows, my lord, a legislative tool in the Indian legislative devices has always been that a definition clause always starts with, my lord, your lordships are aware, unless the context otherwise requires. That is the elasticity given to every legislation, more or less, in this country by Parliament, that you have to, my lord, adopt or adapt to 20, 30, 50, 70 years later. Can't keep changing the law, can't keep changing definitions. So you have, unless the context otherwise requires. So if the context requires that a man and a woman or a husband and wife to be treated as persons or spouses, your lordship will do it by an interpretative tool, number one. Number two, this question, that whether, my lord, the court should wait for the legislature to act. Firstly, it arose, my lord, in Navtej. The court, my lord, entertained rather than waiting for the government to, my lord, remove it or not remove it. But there is, my lord, authority for the proposition in Milord Navtej, Chaira Banu, Puttuswamy, that the court need not wait for legislative Milord interference, and if it is brought to the court's notice that my fundamental right is being restricted, Milord, by the state or by the society because of its mindset, which has to now open up, the court's duty is to act. That is, Milord, clearly laid down. Milord, our lives are passing by. We are getting older. We also want to have the respectability of a marriage, respectability of a couple. What is the point of saying that only criminality in your bedroom is removed? But, beloved, when you go out, there is a passage of Justice Chandrachud, beloved, in one of those judgments, that what matters is what happens in a public space. What is the concrete position? If today, beloved, what is the position? All right, 377 is gone. But if these people, call them queer, call them strange, people call them all different names. If they were to go to different places, people look at them. Look, they are going this way, they are going that way, they are doing this, they are doing that. That, beloved, that is a restriction or an infringement of my right, which is Article 21, to, beloved, live with dignity, freedom, privacy, full expression of thought under 19(1)(a), no discrimination under 14, and, beloved, in 15, as the Lordship knows, there will be no discrimination only on the ground of sex, creed, etc. And only on the ground of sex, Lordship judgment, Justice Chandrachud, talking about Nargesh Mirza, that Air India case, and, Milord, that Anuj Garg, that, Milord, the Delhi hotels case where, Milord, women could not, Milord, become employees. So your Lordships have accepted Anuj Garg, which is an expensive definition of sex to mean sexual orientation. Sex does not mean, Milord, only male, female. And your Lordships have, Milord, discounted the verdict in Nargesh, clearly. So Anuj Garg has been accepted by his Lordship Justice Chandrachud in that judgment, and also, Milord, in Nalsa, where we're dealing with transgenders, there are passage after passage that if you have to give them equality, that equality, Milord, also must reflect positively. So you have the negative part, don't discriminate. There is a positive part in 14 and 15, affirmative action also. Milord, sorry to say that Nalsa said that give them reservation. Years ago, nothing is done. Years ago. Your Lordship judgment, Milord, in Navtej, give full publicity. Today I read in the Indian Express, today, your Lordship judgment says give full publicity. People must know that it's not a criminal offense. Don't look at them with this stigma. Milord, years ago that judgment was delivered. Nothing done. And the three ministries today say, we have not done anything and we are not supposed to do anything. If this is the state of affairs of legislative, Milord, interference or legislative response to judgments of this court, I have no choice but to knock at the doors of this court and say, Milord, I have a sense of deja vu. I was here. I opened the case on 377 years ago, before 5 judges, 5 years ago, in this courtroom. This is how, Milord, we reach step 1. And there is a passage in Justice Chandrachud's, Milord, verdict, which I will show, Milord, that this was the first step. That is that sense. This was the first step. Remove that obstacle. Bring them up to the mark with the others. They will walk, Milord, shoulder to shoulder. The Constitution said secular. What is secular? Regardless of caste, creed, color, sexual orientation, full expression. So we are a part of one homogeneous whole, but with the similarities of caste, creed, color, religion. But everybody is entitled in our secular polity, a pluralistic society. Justice Abarwal, Milord, in Coelho, secularism is a part of basic structure. Equality is a part of basic structure. If they are a part of basic structure and a part of the triangle, Milord, I would say quadrangle, not triangle, 14, 15, 19 and 21. If they are a part of that which are inalienable, part of the basic structure, cannot be removed by anybody, cannot be tinkered by anybody, as understood by your Lordships. I am not reinventing the wheel. Whatever I am saying, Lord, is actually a paraphrase of what I have read in the last couple of days from those judgments. And I will show you some passages. I am only going to put the pieces together, Lord. And I have, Lord, for a Lordship's, Lord, convenience, Justice Bhatt might recall, my lord, in that reservation case, I had made a big chart to show you how the judgments went, my lord, in reservation.
B3.
Here I have made, my lord, your lordship found it, my lord, useful.
So
Here I have, just hold on, lord. I have made, my lord, a one-page chart. Starts, my lord, with, my lord, 1860, the penal code. Your lordship, just have a quick glance. It will be easy. This will give your lordship, my lord, a very quick glance. Because I think only Justice Bhatt was there, my lord, in that case. The 5 judges here. Kindly, my lord, just see. Input my juniors, not by me. I only dictated, my lord, the flow. So, yes, so today is the rainbow, my lord. This is the rainbow. Kindly see, my lord, Penal Code by Macaulay. In fact, Justice Chandrachud has used, my lord, the full name of Macaulay, which I didn't, which said Babington. Yes. Then, my lord, these were laws introduced in different colonies under the British Empire. 47 is our constitution. 67, my lord, was the Sexual Offences Act enacted by Parliament, which legalized homosexuality in 67. Now, see, my lord, September 96, US is very, very, my lord, interesting. US federal government enacted DOMA, which stated that federal law shall not recognize the same-sex marriage. Because, my lord, pausing here for a minute, some states had started recognizing. So center came and said, we will not recognize, because they have state and central lordship. So they found, my lord, this DOMA that we want to keep away. Then, my lord, came Lawrence versus Texas. This was a case where there was a raid, my lord, in the house of Mr. Lawrence. And during the raid, he was found to be, my lord, committing an act which was held to be this unnatural act. And he was then charged. Object was raid, but they found him, my lord, in the bedroom, etc. So, in Lawrence, my lord, the Supreme Court upheld the right of Lawrence. It struck down, my lord, that Texas law, which was, my lord, akin to our 377. Then came Nas. Now see 2013. In Windsor, my lord, the Supreme Court struck down DOMA. That is, that federal law was struck down by the Supreme Court, my lord, by the US Supreme Court. Then came, my lord, Kaushal, which reversed, my lord, the Delhi High Court. Then 2013, the UK Parliament enacted another act to confer equal rights and protect dignity of same sex. 2014 is our NALSA. Now mark 15. In 15, my lord, in Obergefell, it recognized the rights of same sex, legalized the same in the country. My lord, your lordship may mark, and I will show the definition of marriage in this judgment is classic. What is marriage? How, my lord, important it is. I'm going to show that. How important it is. And this happened, my lord, in 2015. And this is referred to, my lord, in Navtej and Shaira Banu both. Then, my lord, came Puttu Swami. I am not reading, my lord. But there are some passages, my lord, of His Lordship Justice Chandrachud, as His Lordship then was. And I have given those passages which I am going to read. And some passages of Justice Sanjay Kaul. Then, my lord, Shafin Jahan and Shakti Vahini. Here also, my lord, if I may say so, the common thread is the Chief Justice. In regard to, my lord, the right to marry a person of your own choice. If you have a right to marry, my lord, a person of your own choice in the heterosexual group, and we are identical to them in terms of our right, it follows, it's QED, it follows that we should also get it. And therefore, you will have to, my lord, qualitatively interpret the laws which were framed in 54 to now fall in sync with what your lordships have said in the last 5 years. That is, my lord, Shafin Jahan. Then came, my lord, Article Section 373 of Johar. Then in 2022, US enacted Respect of Marriage Act for protecting validity of same-sex marriages. Currently, 31 countries recognize the same-sex, but I've given the names. Then came Deepika Singh, Lordship, Lord the Chief Justice. Again, right to marry, familial relationships, or even queer relationships as they are called, is specifically, my lord, dealt with, and that it should be, my lord, can be a family unit, etc. Now, see, my lord, the last definition of marriage in 1968 in blacks. Marriage, as distinguished from agreement to marry and from the acts of becoming married, is a civil status condition relation of one man and woman united in life, in law for life for the discharge the other and communities of duty legally incumbent or those whose association is founded definition of sex.
Union relies on. Now it's changed.
Now, my lord, your lordship may mark here, the union relies on the 1968 definition in the counter affidavit. A detailed counter has been filed by the union of 40 pages. So it's not correct to say that I have to now again look at, my lord, what the government will say. They filed a big affidavit, very big affidavit. And they rely, my lord, on the 68 definition. But see, my lord, the definition of 2019, after, my lord, society has evolved. The legal union of a couple. The essentials of valid marriage are parties legally capable of marriage, mutual consent, any actual contract in the form of law. Definition, Lord, of same sex 2019, ceremonial unit of two people of the same sex, whether man or woman. This is the evolution. So, my lord, union, government of India is following blacks, but it is following an antiquated edition. If you are following the same, my lord, definition or the same dictionary, I say follow the latest version. You can't follow a version, my lord, which is 50 years old. So, ultimately, my lord, it is this, not the Chief Justice has put it. I want, my lord, I request, not want, I request. For example, my lord, the two petitioners in the first case, who are they? Two individuals who met, who had a bond of faith, love, partnership. They want to, my lord, reach the status of a married couple, like the other persons, and have a family. They cherish the same, my lord, what is cherished by the others. They want to lead a dignified life, what the others also lead, and not always to be looked upon. Look at them, look at them. For that, your lordships have removed the one block, that they can't go to jail. The second step has to be affirmative, which is a recognition of the right to marriage so that we are equal, recognized by the state, so that, my lord, society then follows the state. Because society, my lord, is resistant to change. Human beings are resistant to change. So society follows what the law is, and the law is what is, my lord, said in parliament or what is declared by this court. That is the law.
The only thing which we'll also need to apply mind to, if you
Right.
look at your chart,
My lord.
if you see the US, September 96, the federal government enacts the Defense of Marriage Act,
Yes.
which says that the federal law shall not recognize same-sex marriage. Then comes 2013, of course,
Windsor.
the UK.
Or UK.
That's right.
Yes.
And then 2013 comes the act in the UK, conferring upon all same-sex.
Lord, Windsor is also there.
Yes.
Windsor, Lord, 2013.
Yes, that's right. Windsor.
When DOMA was struck down, the federal law was struck down.
And struck down DOMA.
My lord.
Right. Then comes in the UK, you have a legislation which recognizes same-sex relationship.
My lord.
And then finally in 2022, you have the US Respect for Marriage Act.
Yes.
2022.
Yes.
So you had in the US something which was debilitating, which was removed from the statute book. Then you have something positive which is enacted in the UK, and then which is enacted in the US as well, the 2022 legislation. Now, what we therefore have to really consider is exactly what the other side is urging.
Yes, I understand
That
the drift of the question anyway.
these essentially matters where even in the US and the UK, legislature has intervened earlier by outlawing and later on by recognizing. In the absence of legislation, how does the court go about it?
Yes, I understand the question.
Is there a contra? I mean, is there any indication in our legislation precluding the court?
So, my lord, yes.
Or is there a legislative space within which the court can then
Yeah, I understood the question. My respectful submission, my lord. One, my lord, your lordship may see the judgment is over Jeffel in 2015.
What is the right of marriage and what is the constitutionality of an enforcement of right of marriage? Because what they are saying is you live together, you want to do whatever you want, but you can't tell that you want to perform whatever ceremony you want to do or whatever you call it as a marriage. But you can't give an imprimatur and say that that will be registered or recognized. Therefore, we'll have to go back to what is the enforceability of a right of marriage.
So, my lord, if I may answer first the Chief Justice. My lord, if your lordship sees 2015, I have understood the drift, my lord. There the legislatures acted. They acted pursuant to the judgments or feelings of people. They acted. Here, but in 2015, my lord, as far as Obergefell is concerned, it recognized the right of the same-sex marriage and legalized the same. That was a judicial imprimatur. It legalized.
Correct me if I'm wrong.
Sorry.
There were constitutions and there were laws which were amended or enacted which prohibited gay or same-sex marriages. Same-sex marriages. Obergefell actually struck down that and said,
Right.
you have a right to marry. Now, the wheel has turned a full circle where you have a complete federal cover in the sense that you have a
Yes, yes, your lordship is right.
right? So we are at that stage.
Yes.
So
Yes, yes, your lordship is right.
Put is we are at that stage. So how do we go about this?
So, my lord,
One is the declaration part
which I am seeking. My lord, what I am respectfully submitting, answer to both of your lords, three of your lords. My lord, if, as distinct from UK and other places, if we have a fundamental right under 14, 19, 21, whatever, to be treated as identical and equal to our other brethren, then the full enjoyment of our rights to be equal to them includes the right of dignified life. If it includes the right of dignified life, which includes the right to choose a partner for marriage or choose a friend or a freedom of expression, whatever we want to express, need not only be in writing, expression can be, my lord, in love or other forms. And that it is now settled that it is innate, it is not an acquired, my lord, thing, call it queer, call it what you like. If the rights have to be identical, then I must get the recognition of my union the same way as the recognition of the union of two others. And since it is based on an infraction or an implementation of my fundamental right, I can come to the court and the court need not wait for the legislature. And there is a direct passage, my lord, in one of these judgments in Shahraman. So, my lord, I can't keep waiting. There can't be a mandamus to the legislature. Legislature may or may not do. I cannot force the legislature, neither can the court. By that time, our lives will have gone. And our fundamental rights will be in name. That there is 5 judgments of the Supreme Court saying that you have the same rights, same panoply of rights, passage after passage. If it is the same panoply of rights, there must be a remedy. And the remedy can only be a declaration to that effect by the highest court of the land, saying that this is a fundamental right. And once it is the imprimatur of this court, then, my lord, it must follow that the state is bound to respect it. Then the society will respect it, and the stigma in the workplace or the public place will then go away, and I'll be able to enjoy, my lord, a unit of marriage, a unit of family. Because that is what is accepted in our society. So in short, I need not wait for Parliament to do what it wants to do, because there can be no mandamus. And then your lordships have said repeatedly, if fundamental right is involved, the doors of this court are open to an individual. I have a right to come here. I have a right to complain that this is what is happening to me in real life. You know, it is happening to us in real life. When we go out, when we talk, when we meet people. Slowly, my lord, it is being accepted because the criminality is gone, but not to its full panoply. Because people say, what right have you to get married? Which law? Which court? You got a judgment from the Supreme Court in the first one. Where is the second one? So unless and until, my lord, I get a recognition of law under Article 141, because that the other legislative thing is not available to me. Vishakha, whatever. If I have, my lord, a right, that right must be examined by the court, and if found, it must be guaranteed. 32 itself is a part of fundamental rights. It must be guaranteed by the court. How will the court guarantee it? My lord, it's not a case of property that your lordship will take it from him and give it to me, or some money, my lord, taken from me and give it to him. Your lordships will, my lord, give it by a process which is known to law, which is, my lord, interpretation of my fundamental rights, and thereafter interpretation of the law concerned. and then leave it to Parliament that this the court has done. If you want to formalize it in law, as Justice Bhatt put it, if you want to formalize it in law, you jolly well amend the act or do bring a new act, as these countries have done. But if you don't, the law can't remain static. Law moves, society moves, there's evolution. Rights are different, things are different, thoughts are different. Therefore, the court will act when it is called upon to act. It will do whatever it can within its judicial parameters.
So in other words, like two alternate lines of approach for the court. Assuming you are right that you're entitled to a declaration.
Yes.
I mean, assuming, of course, we have to hear the other side. Assuming you are right that there should be a declaration of the right to marry,
Yeah.
then there are two courses of action according to you. Either the court then finds a legislative void in that Parliament has not legislated expressly to recognize the right of marry. And therefore, finding a legislative void, you supplant that deficiency so long as Parliament enacts law. The other option is to locate the modalities for implementing that declaration in existing law.
Correct. So, my lord, my short, most respectful answer would be, if you take Vishakha as an example, in Vishakha, there was no law at all. The court laid down a set of rules which was to work as interim law, if I may use that phrase, interim law or rules and regulations under Article 141 till Parliament acts. Parliament then acted. But the void was filled up in Vishakha in this form. I am saying that in our case, because of our past history, Vishakha had no history. There were no cases before that. We have past history of Puttu Swami, Navtej, all these cases, Shafin, etc., etc. In that past history, all I am requesting is the second step, and the second step to be implemented not by the Vishakha rules, but by virtue of the law already available by a process of legislative interpretation. That's how I would put it.
The vacuum which it filled in and
Yes.
the law which came in. Are you canvassing for filling in a vacuum, leaving it to the legislation to do what it wants?
No, my lord, I am not saying that your lordship may give a declaration, then leave it for somebody else. No.
Therefore, I asked that question.
Yes. Because, my lord, life is passing us by. We can't wait. How long will we wait?
So you're looking at an interpretation of the legislation as it stands that should be expansive. This is what
Can't hear you.
So it's from there.
I know. I can't hear that conversation. Can't hear it. What happened?
They are discussing. The bench is discussing.
If I have a constitutional or a fundamental right, and your lordships declare so, and this act remains the same, then there is a conflict between this and the constitutional or a fundamental right so declared. So one way is that this must give way to the constitutional declaration. We don't want it to give way. The simpler way is to read it down, to be in accord with the declaration which I am seeking. Yes, because, my lord, legislative drafting of 1954 to, my lord, my constitutional right after 50 or 70 years. This drafting cannot stultify what I am constitutionally entitled to get If I am right, if I'm wrong, it's all over. If I am right to get a declaration of the nature that I am seeking, my lord, in 2023, then there is no way that, my lord, a drafting of a statute in 1954 will, my lord, we will.
Part, my lord, there are two thoughts. The in
That side is not being shown. The solicitor side.
our model, where your lordship in constitutional adjudication have equalized and brought the left out category into the existing category, my lord. Not just the executive instruction case in Nakara. In All India Sikkim old settlers recently, following Vishnudas, Handimal, ITO Lawrence and other cases, where, my lord, some people were left out of certain benefits. Your lordship said striking down will deny everybody the benefit. I will now equalize them, my lord. A good body of case law. The other is the Fowry model, my lord, of South Africa, where they said the common law understanding and the statutory understanding is unconstitutional. We strike it down, but we suspend the declaration. No doubt in South Africa, there's an express provision in 172 permitting that. But, my lord, that was how they equalized it. But your lordships have gone one step further. Read in, my lord. But your lordships have read it in, my lord. Nakara was an executive instruction case, but I've got statutory provisions where your lordships have equalized the left out category. The last of which is, my lord, the judgment 3 months back in All India Sikkim Old Settlers, where the Indian origin settlers who did not give up citizenship, my lord, of India, were left out of the Sikkim register. And our Income Tax Act, my lord, confined benefits to people who are in the Sikkim register. So our argument was, we never gave up the citizenship pre-accession. Lordship said, yes, we will now equalize you.
Different ways where reliefs are molded.
Reliefs are molded.
Prabhakar.
That's the rent control matter.
No. During an interregnum period, the retirement age has been decreased from 58 to 55.
Oh, yes.
This court, by constitution bench, upheld it. But later, due to public pressure, it was restored.
Yes.
In between, people had retired.
Nagaraj.
And what was restored was with retrospective effect.
Yes.
The court said not giving retrospective effect is resulting in discrimination and gave it retrospective. One of those rare instances where relief is molded in a particular manner, where legislation intends a certain consequence.
Consequence, my lord.
So,
Now,
Vishwanathan,
my lord, in
will it not
Sikkim,
involve
the classic case where your lordship equalized it. So, my lord, that need not, my lord, deter or, my lord, hold back the court at all. If your lordships find that confining the status of marriage to heterosexual couples is wrong, and this is, my lord, a status which requires recognition by the state, denied to a set of people who otherwise have fundamental rights. Your lordships find that, your lordships have already, according to me, in Nowtej, when your lordship said equal platform, words are, my lord, very specifically used. Your lordships will, my lord, say that they have to be recognized and brought into the sphere. It is for Parliament to tailor law to bring it in accord with fundamental rights, my lord. It can never be that, my lord, you await for them to legislate. That will be, my lord, submitting to, my lord, popular will, which, my lord, is completely contrary, anathema to fundamental rights. The whole idea of fundamental rights is to, my lord, to keep it out of the reign of majority.
Now that we have understood, broadly we've understood the canvas of the matter, then we can really, at least at this stage, we are not ruling it out for the future, we can steer clear of personal law in that case. So if we steer clear of personal law, then perhaps we make the first, I mean, that is one possible option as you opened it up.
As far as two of us are concerned, we are not leading. There may be other people.
My lord, there are concerns about the Hindu marriage.
Because it may not be necessary for the court then to get into more vexed issues pertaining to personal law.
It's codified.
Yes, my lords, Hindu marriage, the
It's
Hindu Marriage
codified.
Act,
So perhaps you can all address us on this aspect. That's why when we began, we as
Can I take 2
No,
minutes?
just a minute.
5 minutes.
Just a minute. The possibility,
The states must be heard. It's a constitutional issue.
Dr. Guruswamy?
my lords, thank you. My lord, the Chief Justice may recognize, my lords, that the Hindu Marriage Act is not an issue necessarily of personal law. It is statutory law. And we will demonstrate that. The terms of the Constitution, the reform of the Hindu Marriage Act has always been in the context of statutory law. So, my lords, to that extent and that extent only, in the context of statutory law and making statutory law workable, because my lords will know, my lords, that the origin of the Hindu Marriage Act, the Hindu Code, did something that was not permitted in sacramental Hindu law, which is intercaste marriage, Sagotra marriage, divorce,
Inheritance to
Dr.
inheritance.
Guruswamy, but there's also Dr. Guruswamy, there may be some amount of sage wisdom in also going about our interpretative task in incremental manners, because otherwise, do we then confine ourselves only to the Hindu Marriage Act? Then what about the Parsi Marriage Act? What about the Muslim law? What about the Jews? What about the Buddhists? A lot of other communities. Therefore, perhaps one option for the court, because the constitution itself and the law is itself evolving. So, and the court has to be mindful of the fact that we are doing by process of interpretation what you're calling upon us to do. So it may be, there may be some element of judicial discretion, and perhaps going incrementally, covering a canvas for the present, which would substantially then, assuming that even there you are right, because you have to hear the other side, confine yourself to this incremental canvas, and then allow society to evolve, allow Parliament's perceptions to evolve over a period of time, because Parliament is also responding to the evolution of society over a period of
One
time.
is the canvas after Ms. Guruswamy is finished. I want just 3 or 4 minutes. We finished?
Yeah, go ahead.
But it's only 3 or 4 because learned friend is given, my learned friend is given.
Because we can't deny the fact.
On canvas,
We can't deny the fact that there is undoubtedly the legislative element also involved, which is why they're saying states, the parliament, what the
my
solicitor said.
respectful submission.
Having regard to that, we need to balance out various facets. So this might be perhaps one way forward.
That's the only thing I'll say to this. Is
So we don't have to decide everything to decide something in this case.
no, my lords, I follow. I follow. The only thing
There are,
I'll say to,
Swami,
yes, my lords.
one is the channel pointed out by Mr. Rodri in a restrictive sense that only construe the Special Marriage Act. If it founds favor with us, it will give us status of marriage. If it not, he rightly said you are out. Therefore, whether other issues at all arise or don't arise, will depend on how we interpret this aspect. Other issues may survive for another day, or may not survive for the time being for another day, depending on what view we take on this core issue. And in the wisdom, as the Chief Justice said, sometimes incremental changes in issues of social and society ramifications are possibly a better course. There is a time for everything. There is time for some things to come. Therefore, what was being suggested was, can we, for the time being, confine it only to this limited issue? Don't step into, let me complete. Don't step into personal law issues under different religious norms. Don't get into any of those issues, but only say that, can the Special Marriage Act be interpreted in a manner by reading into it a general, a gender-neutral situation, period.
Can I say?
And perhaps you can then help us, you can assist us, and we'll ask the solicitor also to assist us on how we can sort of develop the notion of a civil union, which really finds recognition in our statute, namely the Special Marriage Act. See, because now, for instance, I'm sure you wouldn't also deny the fact that between the time that Navtej was delivered and today, our society has found much greater acceptance, say, of same-sex relationships. For the last 5 years that we have seen it unfold,
Definitely.
and that's very positive, because you find that there is a greater acceptance in our universities. And by the way, our universities don't consist of only urban kids; they all come from the smaller areas. Yes, but there is this acceptance which is evolving. So in this evolving consensus, the court is also playing a dialogical role to create that consensus and move towards a more equal future. While being conscious of our own limitations, which we can't deny in the legislative arena.
I follow. My lords, the only request I would make is that the question may be left open to be adjudicated.
Obviously, we're not going to reject what we don't.
Yes,
we can always confine our canvas and then not reject.
Yes,
obviously not.
And
That is not necessary for the court to do at all.
Simply this, that the second point is simply this, that marriage is not only, as if that were not.
But leave broader and broader issues for an evolving future.
Yes, but marriage is not only a question of dignity, as if that were not enough. It is also a bouquet of rights that LGBTQ people are being denied post-Johar. Right? Those rights are simple things. Bank account, life insurance, medical insurance. I, for instance, frankly,
rental accommodation.
I cannot buy SCBA medical insurance.
Citizenship.
I am a member of the SCBA bar. I cannot buy my family medical insurance from the SCBA. So this is the reality of how rights are exercised. Rights are exercised when you are able to protect your relationships. One facet of that right is a constitutional value of dignity, equality, fraternity. The other facet of that rights is the day-to-day business of life. And the day-to-day business of life is all of these things. Now, when we look at law in India, and all common law is premised like this, that most rights flow from this notion of blood relationship, i.e. either being born into the family or being married. That is the problem, my lords. And so, therefore, short of full marriage, whether my lords find that under the Special Marriage Act or be that as it may, short of full marriage, it will mean, if it's short of that, it will mean that subsequently, not just Mr. Rodgi, Mr. Kripal, me, we will keep coming back to court to have to litigate individual issues of discrimination. I am not able to nominate my partner for life insurance. Now, these are not theoretical issues. This is our life. Right? So therefore we say marriage, because that is the notion, not only for society, but that is the notion that the legal framework, which is premised on common law, understand and takes within its fold. So not, therefore, my lords, respectfully, therefore the problem is that anything short of that, if it is a civil union, so this correspondence will now start, my lord, with insurance company, with banks, with hospitals, with wills, with estate duties, with anything that is prerequisite to being able to live a life outside the home, including buying that home. So the statement, and so there are folds here.
Mr. Rodgi, taking a cue from what she says,
Yeah.
see, even in Puttaswamy, when we laid down the right of privacy,
Yeah.
we were conscious that it had many nuances. We said we can't beforehand take all nuances into account and rule on this thing. As it evolves, things will evolve. That's the basis of the.
These are absolute day-to-day issues.
So,
Take the Income Tax Act. The two partners can't give a gift. Gift is free of tax,
Rodgi,
but provided without you are married.
if you succeed, I'm saying if you succeed on the fundamental issue,
Yes,
that it can be read into,
things will work out.
many nuances will start, may take time to work out, it may require more visits to the court, one can't say. But it is very difficult to say that we work out all possible nuances now, even the nuances which you think exist at the moment, to be taken as a bundle of things and dealt with.
So,
therefore, the suggestion which was following was, let us, if we confine it to this fundamental issue under a particular act, that's it.
Yes, well,
We don't touch personal
I-
laws,
I-
we don't touch anything else. We don't get into anything else.
But on the canvas,
on-
I want to say this first.
Yeah.
On the canvas, just 1 second. But on canvas, there are two words here. Of course, on the confinement, it is with great respect, the better profitable way of doing it. There are very valuable arguments by the Hindu Marriage Act batch, or even by other personal laws. Both of us, in the two lead matters, are not arguing that. We are only in SMA. So, a way to start would be to limit it there. I entirely bow down to what is following for my lords. But on the canvas, just 3 or 4 minutes, there are two crucial words here: marriage and persons. Same sex is a slight misnomer. The correct word is person, not same sex. I'll just take 3 or 4 minutes first. Marriage, largely, my learned friend is covered. Whereas there is two categories of consequences. These are consequential issues she is raising. One is the minor or major secular consequences of marriage. Your lordship is not in this matter. In the event that your lordship holds marriage to be this way or that way, not creating an empty shell called the word marriage. It has to have some consequential benefits. Marriage, in any case, now you can have a live-in. You need not even call it marriage. It is because of the consequential benefits. So your lordships may need, this is entirely a lordship discretion. I understand it's a great advance in law if your lordship even were to interpret same person marriage as a marriage. I'm not at all diluting or reducing that. But your lordships, according to me, even in this more limited canvas, must consider traveling a little ahead. One category is what my learned friend has said. These are secular incidents of daily life. They involve nothing beyond that. And your lordships can have a reasonable listing. Now, there are larger issues which your lordship will explicitly keep open. I would say that even those can be covered by marriage, but possibly, we are too early to start doing that. There is succession law, certain aspects. There is adoption law, certain aspects. There is certain other things. We are not at all, giving it up or lessening it. But your lordships in this, the crucial word which fell to the Chief Justice is incremental. Well, I always believe that your lordships in such matters is like a rubber band. Your lordship expands incrementally slightly. You stretch the rubber band too much, your lordship is pushing pressure that the rubber band will break, because that slowly movements is on the societal view of the rubber band. Now, adoption, according to me, is crucial. Is crucial. There may be some non-adoption issues which your lordship may not consider crucial. I'm not able to, in fact, itemize, but your lordship will guard against holding on the left hand, in the event your lordship so holds, that marriage of same persons is valid, and on the right hand, make it an empty shell. That is point one. Point two of the canvas is even more important. The point arises from not having to come to your lordships every day. That's why I said the word is actually more appropriate. I've looked into this, some literature, same person. Now, your lordship has got, one is heterosexual marriage. Lordship will call it this side. One is man-man or woman-woman, which we call homosexual or lesbian, on the other side. Now, there are two actually parameters of differentiation. One is sex-based, which must include between the man and woman sex, there is also a whole range of combination of persons with special biological features. It's not only man, it's not only woman. The second category is gender. That is the masculine, feminine. So a male body can be imbued and overshadowed by completely female psychological instincts, and vice versa. So therefore, once your lordship holds today, assume, as a matter of argument, that your lordship were to hold that same sex marriage is valid. Same sex in the sense of man-man, woman-woman. It is not intended that persons who are in this, what is known as the whole range of shades, the complete spectrum. What your lordship we tend to say LGBTQ. I looked it up. It is L, lesbian, G, gay, B, bisexual, T, transgender, Q, queer, I, intersex. And then your lordship says A, asexual. And then your lordship says plus plus. The actual correct thing is, so this plus plus is a whole shade, a spectrum of different hues and colors. Now, clearly, if your lordship were to hold same person marriage, your lordship doesn't mean to limit it to same sex marriage. In the event your lordship were to hold, so that your lordship doesn't have a balance to borrow a new person coming here and saying this. So the correct formulation would be two consenting adults. I'm only giving a summary. Two consenting adults along the bodily, gender and sex spectrum. Either you define by gender or by sex spectrum. This is the other facet. Now, all of this can be profitably started with SMA, because your lordship is making a start. Were your lordship to leave the rest of it explicitly open, or your lordship may have a deferment and have it considered separately, it's entire lordship discretion. They have also valuable points. I have not only the Hindu Marriage Act category, other people also. Hindu Marriage Act category is there also. Secondly, let us be very clear. I heard with some alarm, my learned friend's opening intervention. Nobody is arguing at the moment, nobody, I will not say, at least the two of us, or the three of us, are not arguing personal laws at all.
We are also not. We are not.
Number three, we are, what is the meaning of this repeated thing about state intervention? Your lordship, for the first batch, is interpreting this way or that way, whether SMA, and our arguments, that is my arguments, are in two parts. One is these fourfold parameters of discrimination, which is the most important, 15, 14. Second is freedom of expression. The very interesting facet of freedom of expression, the lordship has said, is symbolic in a community sense, not only individual. Third is dignity, 21 and other things. Fourth is how to remedy it. And the second part of the submissions is the entire notice objections regime of the SMA. That part would have to be held unconstitutional. The first part is interpretive. If your lordship is with us on that, the second part would have to be unconstitutional.
The notice issue is even in a heterosexual marriage, because you are saying that even in a heterosexual marriage, the fact that you have to give a notice and have people object to whether there should be a marriage or not is unconstitutional.
The funny part is, and this is just an aside, that the object, howsoever noble, of having this section 5 to 10 regime is being proved by statistics on the ground to have the exact opposite effect. Exact opposite. Your Lordship invites opprobrium, oppression, physicality, violence, elimination, extermination. And I'm asking myself one question. Malas, your Lordship has conditions of marriage in all, even Parsis, Christians, Hindu Marriage Act, other acts. Conditions of marriage are there, but something or the other is there. If you give an affidavit saying I'm satisfying the conditions, and your Lordship subsequently files the affidavit to be false, or any spouse finds it to even a third party find it can be struck down. It's void or voidable, it's struck down all the time. You don't need to have a notice period in advance after the conditions. This is peculiar to only the SMMLs. Your Lordship is not allowing those conditions to be violated by the non-following of objections. It's a absurd situation. Now, that being the situation. Yes. Sorry, Malas, I can't. This intervention about state objections.
No, I'm saying therefore, you say you don't want to touch personal laws, correct? And we've also put to you, don't touch personal
I
law.
have not touched.
Then the argument is in a very limited compass or
Focused and focused.
then confined is, can we in the Special Marriage Act read a person instead of the definition of a woman or man
That's all.
That's all.
and leave everything else for some
Better day.
good time in the future?
That's
My lord, just one aspect.
and
my lord.
no state intervention inhibits your Lordship's.
May I then proceed?
My lord, just one aspect.
I think then
One
we can,
minute.
I think we'll now get back to
One
Mr. Rodgi. So we'll get back to Mr. Rodgi.
My lord,
Now
my lord,
clarified. 1 second, just 1 second, 1 second. We have, I think all of us on the bench have now clarified the area, or you may call it the limited area or the area that we are going to explore in this case. Let's hear Mr. Rodgi on that, because I
My
think
lord,
now.
my lord, just
that-
on the ambit,
my
my
lords.
lords.
My lords, briefly,
My
just
lord,
on the
one
ambit, if I may be
part of
permitted.
this,
My
which
lords,
we
we
need
have
to
challenged
show.
in addition the other two secular legislations, and many of us have, which are the Foreign Marriage Act and the Citizenship Act.
My lord,
My
that's
lords, with regard to the Citizenship Act, the word spouse has been used in 2015, subsequent to all of these other legislations. So if the doctrine of casus omissus is applied, all that is required is very, very low-hanging fruit, my lords. All that is required is to be said that spouse means spouse.
See, one thing is, either we confine it to this, the debate will be limited and we'll know whether we agree with you or not today.
my-
If we don't agree with you, nothing survives.
so.
All those issues, all other issues don't survive.
Lords, when you are
If we, one
My,
thing,
my lords,
if we, suppose we agree with you on the
Yes, my
limited issue, then in what ramification, what nuance the other thing survives will be a second innings,
my lord,
second, third, what time.
Look, the Foreign Marriage Act is actually a secular act, which is really a takeoff from the Special Marriage Act. So that would have to be included in this
You
canvas.
can add supplement.
It is only
Let's do this. We will,
is
let's do this
one of
now.
the
We'll,
same.
we'll now start with Mr. Rodgi's submission, so that we can now look at it,
And I'll
we can
follow
now
up.
look at it with a sense of
I want
I'll
to.
follow
a
up.
constitution bench hearing.
So that it's there. My lords can tell us whether we should then address. My lords, as Dr. Singhvi has already addressed, the petitioners before you are not necessarily same-sex couples. In fact, in my petition, the Rituparna Bora petition, there are petitioners who have anonymized themselves because they are coming from oppressed castes and communities. They are trans persons, irrespective of sexual orientation or gender identity. The relationships are in place. So perhaps Same sex will not include them in that description. I will.
Yeah, therefore the emphasis was on personhood.
Person, same
On
person.
person.
Same person. Aspect, we are also chosen family.
Consenting
We won't
adult.
say
Person.
typical family. Can they be, like there is a live-in, can they be a chosen family, particularly when my natal family is hostile? These petitioners have faced hostility and violence from the natal family.
That's the perspective we wish to give.
A chosen family, both to take care of them and the accruing rights.
All right. Now, Mr. Rodgi, you can
No,
open now.
Can I?
My lord, as far as I'm
Mr.
concerned,
Rodgi, now tell us about what's the time estimate for you?
my lord, all my time has been hijacked by people on my side.
No, but now we sort of, now the constitution bench begins as a constitution.
Can I?
Now confine yourself to this.
Only this.
My lord, your lordships,
Yes, only
while,
this.
my lord, your lordships, while fixing the remit of the matter also, your lordship said that we would hear the side. My lord, would your lordships like to consider hearing us? Your lordships have fixed the remits.
All right. Yes, certainly, Mr. Yes, Mr. Mr. Mehta. Certainly. Yes, Solicitor.
Lord, and this is, my lord, I must, my lord, make it, my lord, I in fact achieved an impossible thing today, my lord, making my lord the Chief Justice angry. Few people have done in past, but I am not in very excellent company, my lord, I must confess that. Lord, first of all, the question really, my lord, we are misdirecting the question. The question is not right of equality, right of dignity, or right of privacy of persons who belong to LGBTQ community. That is first. The question is right of conferment of a socio-legal status and whether that can be done by judicial adjudication. But so far as, my lord, kindly give me 15 minutes, my lord, to give the chronological events. Lord, there was no law governing, my lord, the rights and other rights and other, my lord, immunities to the LGBTQ community, my lord. Nalsar judgment came, thereafter Navtej Johar came. Lord, now kindly see, my lord, my affidavit. I am not on the merits of the matter, my lord. On merits, I have different arguments. Please see the Transgender Act. Most of the arguments, my lord, are covered. There is no legal lacuna. There is a statutory framework and there is a conscious omission by the statute. My lord, in my IA, my lord, I have annexed the small act. My lord, this is 2019 act after Navtej Johar.
I'm not talking about transgenders here. Lord,
Your
my
lordship
case is
have
not on transgenders. My case is not on
My
transgender.
lord, my learned friend may allow me now. My lord, I never interrupted him.
But then, sir, I am on my legs. I want to finish my thing.
My lord, he has not seen the act. Otherwise, he would not have said this.
Wait. We have permitted your side to.
I know that.
Just open and
To
give
get
us
a perspective.
No, I am not saying no, Lord.
You shouldn't plead violation of
No,
article.
I'm not complaining. I want to get on with
You
it.
must also get a right to set forth the contours and we may be able to put some.
I appreciate. No, I'm not.
How we are limiting what we propose to limit. So that
Lordship.
then, unless you know what he has to say, how can
Lordship,
Lord, this is, of course, my lord, subject to my first respectful submission about the maintainability. But, my lord, just I'm assisting your lordships on this. Lord, this comes after your lordship's judgment of 2017, Navtej Johar judgment. Lord, please see, my lord, so that my learned friend rest assured, page 34. Your lordships have that, my lord, my application.
The act actually. You've got the
Act, your lordships have the act, my lord. Kindly see section 2. I'll not read all sections, my lord, some of the sections. Appropriate governments, your lordship can skip. Establishment, defined. Family, defined. Inclusive education, defined. Institution, defined. Please come to 2K. Transgender person means a person whose gender does not match with the gender assigned to that person at birth and includes trans man or trans woman within bracket, whether or not such person has undergone sex reassignment surgery or hormone therapy or laser therapy and such other therapy, bracket over, persons with intersex variations, gender queer, and person having such socio-cultural identities as so-and-so, so-and-so, so-and-so. Correct, my lords? Your lordships concern freedom of choosing sexual orientation. No objection, my lord, cannot have any objection. That's my lord's judgment. freedom of privacy, no objection, act take care. Discrimination, there cannot be, the act takes care. I'll my lord show to your lordships. The limited question is conferment of a socio-legal status and whether that can be done by judicial adjudication, and I'll come to special marriage act. Lord, now please see prohibition against discrimination. Lord, all arguments that we are not getting this, we are not getting treatment, we are not getting, Lord, please see this. No person or establishment shall discriminate against transgender person on any of the following grounds, namely the denial or discontinuation of unfair treatment in educational establishments and services thereof. And transgender here means LGBTQ plus, not my lord, transgender as we colloquially or my lord, conventionally understand. The unfair treatment in or in relation to employment or occupation, the denial of or termination from employment or occupation, the denial or discontinuation of unfair treatment in healthcare services, the denial or discontinuation of or unfair treatment with regard to access to or provisions of enjoyment or use of any goods, accommodation, service, facility, benefit, privilege, or appropriate or opportunity dedicated to the use of general public or customary available to the public, denial or discontinuation of unfair treatment with regard to right of movement, denial or so-and-so unfair treatment with regard to right to reside, purchase, rent, or otherwise occupy any property. These are all criminal offenses if there is a denial. Denial of access to removal from unfair treatment in government or private establishment in whose care or custody a transgender person is, then recognition of identity of transgender persons. Recognition of a transgender person shall have a right to be recognized as such in accordance with the provisions of this act. Right to dignity, right to personhood, as my lord, the Chief Justice said. A person recognized as transgender under subsection 1 shall have a right to self-perceived gender identity. Application for certificate of identity. My lord, statutory certification is given that you are falling within the definition of transgender under 2K, based upon which you exercise your rights. And if there is any violation, there are penal provisions. Then issue of certificate, change in gender, my lord, even if my lord, in LGBTQ, there are changes which take place, my lord, because of hormonal therapy, other therapies, operation, etc. My lord, there is a concept of fluid gender. Sometimes a person is male, for a few days he is female, etc., etc. Let's not go into it. That's on the marriage, and we have much to say on that. Change in gender. After the issue of certificate under subsection 1 of section 6, if a transgender person undergoes surgery to change gender, either as a male or female, such person may make an application, my lord, then he gets a new certificate. Obligation of the appropriate government. There are statutory obligations, either central government or the state government, as the case may be, to take steps to secure full and effective participation of transgender persons and their inclusion in the society. The appropriate government shall take such welfare measures as may be prescribed to protect the rights and interests of transgender persons and facilitate their access to welfare schemes framed by that government. Appropriate government shall formulate welfare schemes and programs which are transgender sensitive, non-stigmatizing and non-discriminatory. Appropriate government shall take steps for the rescue, protection and rehabilitation of transgender persons, etc., etc. Then, my lord, obligations of establishments and other persons. Lord, there is a provision for reservation for transgender persons. It's not, my lord, right now nobody is arguing the question of dignity, respect, privacy, etc. Right to choose one's sexual orientation. The definition is widely worded. Any deviation from the normal sexual orientation is protected under 2K. And, my lord, rights are given, and any discrimination is criminally prosecutable. Right now, the limited question is, can by a judicial adjudication process, this honorable court create a institution of marriage for the simple reason, Lord, whether we like it or not, whether they give it up or not, whether, my lord, your court would go into it or not, it necessarily affects personal laws. Lord, Hindu Marriage Act is a codified personal law. Islam has their own personal law.
Part of it is not codified.
Part of it is not codified. Hindu law also, part of it is
Getting
not.
into it, Solicitor, we said
Only a
earlier
minute.
to them that so far as personal laws are concerned, we are not at present getting into that arena at all.
That's not the point. Somebody who is Hindu, who is not here, can come and say that, why did you not give me the same treatment? I want to be Hindu. I want to marry under the Hindu Marriage Act. And if you give benefit,
But we are not getting into it.
We are
Why?
not getting into it. So then where is
your
the
lordship will
speculation?
have to. Right now, your lordship don't have that argument.
We of
There's no
course not.
compulsion we
No,
must get into.
Only a minute. Like, can
We
I?
don't have to decide the broader in order to decide the much more restricted
what he
arena.
said.
Another aspect, and which I that confining the remits, my lord, I have something to say, my lord. Lord, your lordships would have Hindus, Muslims, everyone, whether your lordships go into or not, everyone will be affected, and therefore the central government very respectfully but specifically, my lord, prays that states will have to be heard.
How many times will you
That's
say
the
the same
question
thing?
we are trying to pose, Solicitor. If we are not touching the person, it's like saying that you must touch personal law. We don't want to touch personal law. We don't want to touch personal law, then why state should be heard? We are confining our limit at the moment only to one issue. So for that issue, whatever has to be heard
No,
is
my
only
lord,
for that issue, which is
marriage.
under the special. Completed, then you may answer. Under the Special Marriage Act, can we read it in a manner that it is a person? That's all. We are saying we are not going into it. So why should there be a compulsion of the court? You must go into it.
So Solicitor, can
That's
you
it.
give an example of what you're trying to act? Because if the remit is being defined in this manner, how do you say that this has some other repercussions?
Yes,
If you are
Lord,
that's
one Mr. A, he is Hindu. He wants to continue as a Hindu. He wants to get married under the Hindu Marriage Act. He wants to undergo the.
We're not going to address
We are
that at all.
saying we are not rejecting or accepting. We are saying we are not doing it at the
Lord,
moment.
we are then begging the question, my lord,
Maybe
to reach somewhere. We are, my lord, short circuiting the issue, my lord. That's kindly, my lord, allow me. Kindly let me. My lord, I am for the first time begging that I may be heard.
to create something which we are not doing, and then you say
I am obliged.
understand what is that you are saying. We are saying we have confined them. They may have opened a very wide chapter. We said no, we don't want to get into that wide area. We don't get. We are only deciding this A issue. We are not touching other issue. Nobody is being prejudiced because we are neither rejecting it nor accepting it. Then we can't be compelled to hear everything else.
No, nobody is compelling, my lord. At least on our side, we are saying your lordship should not hear.
No,
We are not compelling.
but you are saying don't hear this alone. Hear everything, or hear.
No, I am saying don't hear it, my lord. I am
You are
not.
saying don't hear it at
I
all.
am saying let the parliament hear it, my lord.
That's right. But therefore, we are trying to steer a middle course, which is that we don't want to
Lord,
first say that, well, we will decide
Lord,
everything.
when we are
and
deciding
then be
fate of,
and then be confronted with this argument.
is opening, but
it has several windows have opened.
the window will have to open the entire door. So don't do it.
I would, my lord, kindly on the lighter side and don't take otherwise. Several windows have already opened. Now they are trying to open the door, and I am saying that you will have to ultimately open your entire house.
Mr.
As an
Solicitor,
example, the question is whether those
He is relying on those windows which have opened.
windows have got sufficient breeze inside or not is the question.
Now,
And-
another aspect.
and those windows are willy-nilly going to open whatever we decide, because society is not dependent on.
Lord, I
on
must, my lord,
legal
say as a
arguments.
citizen.
Windows have opened up.
No, I'm no, my lord. I'm saying as a citizen. I'm not saying yes or no. Societal relations, acceptance of any relationship in the society is never dependent either on legislation or on judgments. It comes only from within. Let us accept it, whether we like to accept it or not. But leave it at that. That's my lord more on my lord other philosophical aspects. Your lordships are persuaded to take up Special Marriage Act, possibly my lord on the ground that in one of the section the word used is spouse. My lord, my respectful submission is this, and kindly a person, my lord, not spouse. My lord, my respectful submission is this, and kindly my lord examine this correctly, a little my lord, closely. Even Special Marriage Act, and I will show, my lord, if I have to, my lord, at the a subsequent stage. The legislative intent of the legislature throughout has been a relationship between a biological male and a biological female, including Special Marriage Act.
But Mr. Solicitor,
Number one.
there's a very important value judgment which you are making, that the very notion of a biological man is absolute, or that a notion of a biological woman is also an absolute notion.
Never change.
Which is incorrect.
The only biological man means biological man. It's not a question of notion.
Possibilities of rights.
Yes, of course it is.
None of us.
There is no absolute concept of a man or an absolute concept of a woman at all. That's the whole argument in a broader constitution.
Biological man, my lord, means man only. It means, my lord, biological man. It's not
man
a
is
matter
not a
of
definition
notion.
of what your genitals are. It's far more complex. That's the point.
We stop having rights if we are not a biological.
So even when the Special Marriage Act says man and woman, the very notion of a man and a notion of a woman is not an absolute. Based on what genitals you have.
Lord, biological man means genitals you have. Lord, I didn't want to use that expression.
That's a point of view.
Lord, another thing, for man, irrespective of other attributes than the genitals, there are separate age limits prescribed. Lord, what are we doing? No, that's not an argument. That's not an argument.
Before we said it is not a mandatory thing that the whole society must accept something. Changes have always come.
But your lordships will have to examine whether marriage is a fundamental right. Right to marry, divorce the law is a fundamental right.
That's what I want to establish. No?
Lord, only a minute.
What
Only a
else do you
minute.
want to
Lord,
establish?
only a minute.
Seeking to confine.
Lord, I know my difficulties. Lord. I know my difficulties, but I am still discharging my duty. Lord, there are several acts. If the notion is treated to be a guiding factor to decide man or a woman, then I will show several acts which your lordships would unintentionally make non-workable. I may have, my lord, genital of a man, but if I am otherwise a female, my lord, as my lord possibly trying to be suggested, then, my lord, how would I be treated under the Criminal Procedure Code? As a woman, my lord, can I be called? For 160 statement after a particular hour, I may say that this is only a notion. I may have a biological genitals of a man, but now I am a woman. Well, there are several issues, my lord, which have to be gone into. Better they go into be gone into by the parliament. And your lordships, my lord, kindly appreciate. But the parliament, we have good eminent parliamentarians on both sides, and I can say this based only on my reading. Parliamentary committees are not, my lord, acting the way in which, my lord, we see parliaments functioning. Parliament committees have all parties as members.
The lighter side, they say that real work is done in the parliamentary subcommittee.
Yes, yes. My lord, they call witnesses, they call expert witnesses, they call stakeholders, they decide.
We have both Justice Kaul and I, we have engaged with the department-related parliamentary committee. I chair the E-committee, Justice Kaul chairs NALSA. We have engaged extensively with the parliamentary committee. In fact, part of the reasons why we have this huge support now for the E-committee is because of the
I'm aware of
support
in a different capacity. I'm aware.
But see,
no, my lord, it's not that, my lord. There are certain issues, my lord, which are better left to the discretion of the parliament. Your lordships, my lord, concern the government shares. No discrimination, no breach of privacy, right of choosing one sexual, my lord, orientation. Everything is taken care of.
Mr. Solicitor, you are underestimating the impact which your argument is having on us. don't underestimate the impact which your submissions are having on us. And now it's our turn now to put those problems to Mr. Rohde when he addresses us.
Another aspect, my lord, another aspect.
We know where we are trying to find. We are also
I'm
trying to
fully
see where we can
confident,
draw the
my lord, I'm
lines.
fully confident. I'm fully confident. Only a minute more. Only a minute more.
You may continue. I'm only saying they came with a broader canvas, much broader canvas. We are saying we are unwilling to go into the broader canvas. We are not willing to go into the broader canvas. We are not willing to go into personal laws issue. We are not willing to go into ABCD. Therefore, they have agreed to, for the time being, confine it only to the aspect which we are willing to rule on. And it cannot be said we must rule on everything. We are only willing to rule on that aspect. If that is the only remit which we are willing to consider, then actually their arguments or your arguments, you may have arguments whether it can be done under this act or not, whether even what is being sought to be canvassed by them should be left to the legislature to consider whether they would like to get into it. But the remit or the contours of the argument will thus have to be restricted only to the extent we are willing to consider the issue. It can't go beyond.
I'll just give an example why I'm saying this. I'm just giving an example.
And it is still open to you to argue in response that don't go into even this limited remit. That is again
I'm obliged. I'm obliged. What has happened is this. In Nautaj Johar, when the limited question was decriminalization of section 3 X mentioned in 377, the central government very carefully filed an affidavit that we leave it to the wisdom of the court. We are not, but there we did say in no uncertain terms and recorded by your lordships that this is not an issue where we were even remotely touching about other issues of marriage, etc., etc. But as my lords have said, the window of marriage did open there. Now, today your lordships may not go into the question of personal laws, but the window of that personal law will open. Ultimately, your lordships are dealing with her.
Solicitor, we cannot ever bind future generations after we are gone.
Exactly my submission
is. Are dusted and done.
Lord, that's the
task for the future generations.
Lord, that's from
whether
that's
it's the legislature or the court. I mean, we leave it open to
Lord, that's
future generations to run the country with the sense of
I'm not saying your lordship would bind. Your lordship would never bind. That's the majesty of the court. But your lordship's not going it right now and giving some considering giving some relief would not mean that your lordships have never gone. That would, my lord, open another. That's all okay, my lord. That's okay. But ultimately, my lord, your lordship will have to consider that this even Special Marriage Act does not prohibit. And entry 5 concurrent list is agnostic. It's not on personal law. It's a law of marriage. It's not Hindu marriage, Parsi marriage, or Muslim marriage. It's a law of marriage. It's their right to legalize, not to legalize, provide for many things, etc., etc. And therefore, my lord, again, I am reiterating that my preliminary application, and there is a reason why I am repeatedly reiterating, my preliminary objection be taken up first, and your lordships may issue notice, my lord, to all the states. I'm reiterating that request with a purpose, my lord, with an intention.
All right, we'll reflect on it at lunch and we'll take a call. Certainly we'll now that you.
May I have 2 minutes, please?
Yes, Mr. Trivedi.
Adopting everything which my learned solicitor says, about the canvas, so far as the Special Marriage Act is concerned, even if this court, I'm assuming the lordships are inclined to update it or read in something in this act so as to accommodate the interests of the petitioner. Even then, first of all, the preliminary issue would be whether, the heterosexual unions with whom they are seeking equality. Mr. Koterie himself said that if your lordship holds that they are equal, then the issue of reading in, etc., arises. Without first going into that question of equality, because it is going to be our strong submission, my lord, that there is no equality, my lords. It is one thing that they claim civil rights of different kind, with all sorts of consequences. Many countries, my lord, have had separate, my lord, enactments giving them certain recognition, certain rights, Even in UK, my lord, first there was a law enacted which gave them separately a right, and subsequently, my lord, this equality was granted by legislation. And therefore, my lords, the first and foremost question is, would this court be holding, Lord, because earlier in Navtej, your lordships never granted absolute equality, Lord, with heterosexual union. That was not the issue at all. So the no lordships have not educated us that no judgment should be read, will not dehorse the issues which had arisen in that case. In that case, not the only issue was about the decriminalization, section 377, which in that context, your lordship made certain observations. Yes, as lawyers, Lord, we are entitled to rely on those observations and try to build further, my lords. But then that is not a final authority, my lord, for complete equality between the two kind of relations. One relation which has been existing, my lord, since time immemorial. Enormous continuity for heterosexual union. And that heterosexual union, my lord, as the lordship knows, is responsible for the perpetuation, the very existence of the human race, its perpetuation. Without it, my lord, the society itself will not live. The nations will not be there. But the other relationship, merely because there is love, affection, and concern and care, etc., that's just one part of the heterosexual union. That's not the core of the relationship. The very heterosexual union, this marriage amongst them, this institution is not the gift of law. It has been existing since Rig Vedas, lords. And it's continued. The Manusmriti continued, my lords. And all religions, my lord, so basically, my lord, these marriages have evolved over thousands of years, my lords, and are based on usage, custom, religion, etc. And the core purpose was to perpetuate the human race. Without it, this relationship, my lord, it can't exist. You may have n number of other kind of relationship. Malanitran refers to group marriages, polyamorous marriages, and so many things are existing, and this same-sex is not a new phenomenon. It had been existing earlier, and they never claimed equality. They were never given equality. That's a very important aspect. Go as far back as in history, my lord, they have existed, but not on an equal level. Today, under the Constitution, it is one thing that they want to claim. The question is, therefore, what I'm trying to say is that this fundamental question, are they absolutely equal? Once your lordship comes to that conclusion that they are, then and then alone, the question will be, do we read it in this act itself without any necessity of declaring any enactment ultra vires and so on, lords? And the second aspect is, lords, that even under the Special Marriage Act, there are two aspects. If your lordship looks at one section, 19. On 19, section 19,
Yes.
the two relations, the two unions are different, at different pedestal. Section 19, the manifests the Hindu.
Where are you reading, Mr.? 19.
Section, I'm sorry, section 19.
Go ahead.
The marriage solemnized under this act of any member of an undivided family who professes the Hindu, Buddhist, Sikh, or Jain religions shall be deemed to effect his severance from such family. So there is a consequence on the personal law. Well, that of course will be, they can say that it's my choice, I'm willing to.
Right, exactly.
That's fine.
That's 21.
But then this.
21A follows. 21A follows. Not just 19, 21A. Amended in CRPC.
Now further, degree of prohibited relationship. These are all, my lord, reflections of the personal law.
Yes.
What I wish to say, my lord, is that marriage amongst heterosexuals or the heterosexual union is not a gift of any of these laws. These laws are only regulating the long-standing blood relationship which has been existing in our society. They are only regulatory. Now kindly have section 4.
Subsection 6. It talks of biological man and biological woman. 4C.
Now, kindly have 4B first. Neither party, and in fact in A, the expression spouse itself is indicative of an heterosexual relation. That's, of course, a question of submission on merit. B, neither party is incapable of giving a valid consent to it in consequence of unsoundness of mind, though capable of giving a valid consent has been suffering from mental disorder of such a kind or to such an extent as to be unfit for marriage and the procreation of children.
It talks of
So the procreation of children and the perpetuation of the society, my lord, and the race and the nation is an intrinsic idea, my lord, spelled out in this. Therefore, that question will have to be decided first. And even if you decide it is equal, whether your lordship can still, my lord, read in, change all these provisions so as to accommodate, would be a submission on merit that is not possible even on merits, even if your lordship holds that they are equal. And then see, the male has completed the age of 21 years and the female the age of 18 years. Now, how can, my lord, the question of man and women doesn't arise?
It has to be biological man and biological.
Yes.
Now, kindly have section 12.
So the way these
These are all arguments on merit.
It's on the merits, but I'm just briefly, not cursorily taking your lordship's.
No, this is an argument saying that don't do this, as the solicitor said, because it has various other ramifications. Even under the Special Marriage Act, don't do it. We'll
With respect, I'm saying I appreciate the faults from my lord, no, but I'm saying something else. I'm saying first, because of the historical submission which I made, because of these provisions, etc., and because of the fact that under this act, my lord, the states are empowered to make rules. Therefore, my lord, the states are absolutely essential party, necessary party, my lord, and no adjudication should be done without, my lord, issuing notices and pleading the states.
All right, we'll consider
Particularly,
that.
we have moved an application and I have not got an opportunity, so I must be, my application should be allowed, my lord, and given an opportunity. My lord. Thousands
Yes,
of
Mr.
people.
Bill.
2 minutes, only 2 minutes. Well, it's, at least some of us on this side, at least for speaking for myself, believe in the autonomy of the individual. And I think people are entitled to have a relationship of whatever kind, whether it's the same sex or not, Mullas. I think that needs to be celebrated because that's the way society is moving forward. But having said that, Mullas, assuming your lordships were to say it is a valid marriage, it's fair, Mullas, your lordships can say that. Now, Mullas, supposing the marriage breaks down, they've adopted a child, what's going to happen? Who's going to be the father? Who's going to be the tenant? Under procedural criminal law, Mullas, who is the woman? Who will be maintenance? These are very, very serious societal consequences of that declaration. Either you take it as a whole or don't take it at all. I'm not averse to either. But if you do it piecemeal, it'll create more problems for that unity, for that union, for those two people, whether they're women or they are. In other legislations, when this has been done, if you look at the legislations around the world, they actually reform all the other laws in tandem with it. If you do it piecemeal, you will actually be hurting that very community. And that's very dangerous. I am all for it personally, but I'm not in this fashion.
So are you saying do everything?
Either you do everything or you do nothing. But if you do it piecemeal, you're going to hurt that union.
You are representing which state? Sorry.
Well, I'm not representing anybody. In fact, I need not even argue because your lordships are leaving out personal law for Jamaat. So I need not even argue. But I'm just,
No, I just want to know.
an officer of the
just to
court.
appreciate the submission, I want to know which is the group you represent. If you're not representing,
I'm sorry.
which is the group you represent? Which is the
The
stakeholder?
Jamaat, Mullah. Jamaatul Ulama and
Not parties.
Therefore, Malas, I am out of it, really, because your lordship has clarified it. I don't have to be here. But Malas, I want to, no, just as having practiced here for so many years, I need to.
Yes.
Malas, these are very complex, serious issues. If you decide it piecemeal, it's going to have huge ramifications. There'll be ghettoization. Imagine the impact in a village.
Mr. Sibbal, what we can do is that
Yeah.
at the latter part of the arguments, we'd like you to assist the court for about half an hour or so. Please do.
Deeply obliged.
We come back.
To just take
May I have your lordship's
response to
attention?
what biological,
There are certain other organizations.
Never
example.
Look, we can't be hearing everybody to open their cases. What we'll do is now we've got a broad understanding of where the rival viewpoints are. We'll come back after lunch and now begin with Mr. Rohatgi's
Very well.
submission. I
Grateful.
May I have your
The only thing what we
attention?
wanted to say is, not on the merits, but Lord, you are Bharatiya Sant Samiti, the Hindu chain. I'm not on that, I'm in the
So,
institution of marriage,
now just one
the
thing
society.
on the logistics, Mr. Rohatgi.
Lord, I will finish by 4.
By 4 o'clock.
Yes.
Now,
Dr. Singh.
once you have covered this ground,
Yes.
we take it that the others will only make short supplementing submissions.
Yes.
Who will be leading? Dr. Singhvi, how long?
Dr. Singhvi,
Then me.
Mr. Kirpal wants to say.
Mr.
Dr.
Kirpal.
Singhvi, then Mr. Vishwanathan.
So, my lord, I'll just submit.
Give us a small.
Just give us a list of the order, set
I'll
out the orders so
open.
that we can call out the names
Certainly.
one after the other. And we will take
What
it
we would
that
propose, my
maybe all of you should be able to conclude by Thursday.
Very well, my
So
lord.
that we'll give you until the end of
Yes,
Thursday
Lord, I
for
think
the
that-
entire this
that
side.
would be sufficient.
And the following week we can, Malas.
Even that I feel, once you have addressed.
The others will have
Your
very short
lordship,
supplements.
supplementing. I don't
Yes.
know if you finish today, how much supplementary can there be?
Not much.
Lord, I will place the relevant judgments which will establish according to me that we have a fundamental right, my Lord, to a marriage.
So
and to
perhaps
be
Thursday
solely-
afternoon, the others
Yes.
can start. I think Thursday afternoon, the rest of us can start.
And I'll get my choice.
Highly obliged.
But I would.
May I have a turn for a
But
few
your
minutes
lordships
after?
are rejecting my application.
Mr. Solicitor, Mr. Attorney General?
Yeah, after lunch, by a few minutes,
Yes,
your lordship's
after
time.
lunch.
Very good.
We're highly obliged.
So, my Lord, I want to first establish that we have a fundamental right, my Lord, to get married, have it recognized by the state, and have it registered like our brethren in the heterosexual majority group in society. If, my Lord, we are right, then, my Lord, certain rights flow from that status of marriage. Some of it was being explained, my Lord, like pensions, like, my Lord, there are some income tax provisions, gifts, many other things apart from status in society. That is most important. Lord, I was amazed to hear the other side saying, my Lord, that we are not equal. I heard this submission, that we are not equal to the brethren of the heterosexual group. It's an astounding statement coming, my Lord, from a state. The Constitution does not make two classes of citizens, my Lord. It makes only one class, people of India. Let us start, my Lord. I am amazed to say that we are not equal, as if we must continue to be treated as those, my Lord, who are tainted or stigmatized. That is the mindset today. That mindset continues. And therefore, it is important for this court to step in. Because, my Lord, it has removed one obstacle of 377. But after that, where? That stigmatization continues. And this, my Lord, is reflective of the stand being taken by no less than a state, that where is your equality? Where are you equal? My Lord, let us first start very briefly to have a look and remind ourselves on the preamble of this Constitution. My friend said, how are you equal? We became equal in 1950. Have a look at the preamble. And then, my Lord, I will shortly show the discussion on the preamble in Puttu Swami, in the opinion of his Lordship, my Lord Justice Chandrachud. But first I will show to your Lordship, my Lord, the preamble. And your Lordships know, my Lord, preamble was held to be a part of the Constitution in Keshavan Bharati. It is intrinsic to the understanding of the ethos and the philosophy of the Constitution. And, my Lord, all these articles 14, 19, 15, 21 really flow, my Lord, or are adjuncts of this preamble. Kindly see, my Lord.
Fundamentals are mentioned here.
We, the people of India, having solemnly resolved to constitute India into a sovereign, socialistic, secular, democratic republic. We are more concerned with secular in the context in which we are placed, my Lord. To secure to all citizens justice, liberty of thought, expression, belief, faith, and worship. See the articles, my Lord, which will be involved in this. Liberty of thought and expression, Article 19, Article 21 also, because the right to have dignity to live a full life. Faith and worship, religion, secular, pluralistic. It will go to Article 25, 29. Equality of status and opportunity. The implementing provision will be 14, 15, and 16, which are, my Lord, a triangle. Not the golden triangle, but a triangle between themselves. 14, 15, and 16. And then to promote among them all fraternity. So justice, liberty, equality will allow, my Lord, promotion of fraternity. Fraternity, my Lord, is brotherhood, community interest, assuring, these words are prophetic now, assuring the dignity of the individual. Now, my Lord, this dignity sits in Article 21 in terms of Puttu Swami. Dignity, an adjunct of privacy, it sits in Article 21. And the unity and integrity of the nation. This is very important. So it is not, my Lord, only dealing with these individual rights. It says that justice, liberty, equality will promote fraternity. What will it do? It will assure the dignity of the people of India or the citizens of India, give them the full panoply of rights under Article 21 and 14, 19, etc. And the unity and integrity, my Lord, unity and integrity is a far higher concept than mere individuals. So it will coalesce, my Lord.
Actually,
will have-
Mr. Dradgi, there are two words in the preamble which have not been dealt with too often, which is and to secure to all of its citizens.
Yes, yes.
The first part says to secure to all its citizens.
Correct. I'm grateful.
Secure means to enable them to have the protection of or enjoyment
Yes,
of these
yes,
values.
yes.
So this is-
Affirmatively.
Right, affirmative.
My Lord, affirmatively.
And that is individual.
Yes.
Now the latter part says and to promote among them all. That's very important.
All, my Lord.
So it goes beyond the individual.
Yes, all means the entire society, which consists, my Lord, of citizens having different views, different color, different religion, but we will treat them under one umbrella. They will form, my Lord, and forge the unity of this nation. Why was unity important? Because we had just come after a partition. So it will forge, my Lord, all people together as one unit, but having dissimilarities. And the pluralistic or secular society accepts and understands diversity, plurality, multilingual, multi-faith, multi-religion, multicultural. That was the concept, not.
So justice to each of us, liberty to each of us, equality to each of us, and fraternity among us.
I am grateful. I am very grateful.
The important
So, my Lord, individual, community,
Rodgi.
citizens, and the nation. This is the sweep. Sorry, I'm so very sorry.
Important expression here, which connects at the lowest level to the unity of the country, is the individual.
Yes.
The individual to the nation.
Correct. I am very grateful.
In the context of dignity is connected to individual.
Yes.
And unity is connected.
How will you have unity?
Citizens alone.
Yeah. An individual is a very
Nothing on merits. The artificial intelligence has changed Mr. Rodgi into Dr. Singhvi. Your arguments are recorded as Dr. Singhvi's arguments.
Oh,
Please
please correct
cleaned
it.
up by the evening. By the
Please have it corrected.
No, you'll get more memos.
I may get more briefs if it's my argument, not somebody else's.
I don't think either of you need too many more briefs.
He said in a lighter vein. Your Lordship is right, not. We start from the individual, community, forge the integrity of a nation. How can you do it when you say that these individuals are not equal? We are born with this. I'm pained to read, which is touted in the paper every day, that this is an elitist concept. This is what the affidavit of the application says. Every newspaper carries it now. That this urban elitist concept. When I was doing some research, I found that Nero, the Roman emperor, in AD 54 or 58, he married twice, two men at that time. And he told the imperial court, please recognize this marriage. My Lord Justice Chandrachud referred to the origin of Lord Ayappa. I found it very interesting. I've read it. How was Lord Ayappa born? Milord, a union of two gods, Lord Shiva and Lord Vishnu, but Lord Vishnu in the role of Mohini. I mean, it's very, very interesting, Milord. Therefore, nothing is absolute. The solicitor talked about, Milord, the transgenders. Transgenders is only T out of LGBT. It's only T. LGB is not considered, Milord, with the transgenders. So therefore, Milord, these concepts change. I also heard him say, whether the court decides, whether parliament decides, doesn't matter. It's the society which decides, something like that. Milord, take the Hindu Widows' Right to Remarriage Act, 1860 something. The society was not ready, Milord, for widows' remarriage till even early 90s. You have those widows' houses, Milord, in Mathura.
before 1956, bigamy was not.
My lord, but Milord, the Dominion Parliament in the 1800s moved far ahead of the society and allowed, Milord, the Hindu widows to remarry. But sometimes the mindset still don't change. It didn't change, Milord, even till early 1900s, even till 1920s, 30s, and you have those homes, Milord, in Mathura. So sometimes, Milord, Parliament or the Legislative Assembly acts with more alacrity. Sometimes it acts, Milord, with less alacrity. But here, we have moved on. We have moved on. Your Lordship's declaration to remove, Milord, the obstacle in our way from achieving all this was only one. That is, insofar as the state is concerned, was 377. The second is the mindset. And all this which is argued is actually reflective of that mindset. Heterosexual majority is the only one. That's the only way life is. That's the only way it should be. That's the only way it should be seen. And that is the only way, my lord, marriage must be seen. That, my lord, with great respect, your lordships have said that the majoritarian way must give way to the constitutional freedoms. Can't be that what majority is doing is correct and therefore you squash the rights of the others. All this is, Lord, a part of the judgment which I quickly showed to your lordship. I am not adding anything, my lord, except this, some research I had done, my lord, for all this, but otherwise, this is all, my lord, documented.
Society today.
No, my lord, my friend is right. See, my lord, the Chief Justice referred to this fact. Navtej came, my lord, 5 years ago. In 5 years, we have seen a perceptible difference as to how people view, my lord, people of our community, if you call it that way. Not fully. Some stigma is still there, as I said, in public spaces, etc. That stigma can only be removed by a declaration of the court, just as we had a declaration in Navtej. We'll not see one more thing. It's not only our rights. Look at the rights of our parents. I don't know if your lordship read or not. I read an article
By Mr. Vivek. I was
Yes.
going to say that, yes.
I read the article by him.
In the Indian Express.
Yes, I'll pass it on to your Lordship if it is not there. I read an article. So rights of others are also involved. Rights of parents, how to treat their children, how to treat them in their society, that is the elder society, in their fraternity. People ask me, Lord, what do your children do? Where are they? Etc. etc. So the rights of others, that is, my Lord, one below and one above. Children and the parents. So rights of many, my Lord, are under interplay when you are deciding, my Lord, the rights of these people. That's how, my Lord, it carries on. Now, my Lord, we go straight to judgments. I've read the preamble. Now, no, I'll go to that. Now, my Lord, your Lordship may note one or two things I will not read because they are well known. And then we will go straight, my Lord, to Nalsa, which is the first of this lot. But just make a note, my Lord. Secularism was held to be a part of the basic structure in Bombay. My Lord, we note the page. I don't want to read it, my Lord. It's well known. Secularism was held to be a part of the basic structure in Bombay. 1994, 3 SCC, page 1, paras 145 and 153. Then, my Lord, it was also held to be such in Coelho, which is 9 judges, Justice Sabharwal, speaking for the court, 2007, 2 SCC, page 1, paras 106 and 109. And just as an aside, my Lord, those of who were in this court at that time, Justice Sabharwal said, my Lord, we will start the case on Monday at 10:30 and end it on Friday at 4:30 or 4 o'clock. This 9 judges case. And it was actually so finished. No miscellaneous, my Lord would, some of us who were here would remember, my Lord. This is how it happened. Anyway, then, my Lord, please note, para 1 of TMA which is, my Lord, 11 judges, if I am not mistaken. Chief Justice Kirpal, 2002, volume 8, SCC 481, para 1, only the first line that India is a land of diversity.
He uses the expression mosaic.
Yes. Grateful. Diversity, plurality, secularism, all this means that people who are constituting, Lord, the unity of that nation must move together. They must move together. They are not unequal. That's why do away with.
Justice Das.
Sorry.
In Kerala Education Bill.
Yes.
That too is the first paragraph.
Right. 56.
58.
58. So now, my Lord, we go straight to Nalsa. So I have to now read passages of 4 or 5 judgments.
And we have followed this principle in Ayodhya as well.
Yes.
In fact, Ayodhya, we said that the 1993 Act was an
Yes,
extension of the basic structure.
But, my Lord, I wanted to concentrate on this line. Rather, so Nalsa, Puttuswamy, Navtej, Shafin, Deepika. That's, my Lord, the line which I wish to take. It's all, my Lord, said by Lordship. So we go straight to Nalsa, my Lord. It's a part of the compilation, my Lord, which is on the Lordship's mail. Is it on the mail?
Yes, it's with them. Volume 1. It's with them. Volume 1.
Page 711 of volume 1.
Your note. Your
Yes.
Page?
My Lord, it is page 711 of volume 1 of the compilation.
42 PDF. It starts at 738.
You put the document volume 1 there.
Chief's words.
What's the meaning?
Guy President was.
Yesterday evening, on this.
Oh, the law clerks will assist me.
No,
I have a vested interest in ensuring that justice call also is on the electronic format.
Since there's a small interlude, I must thank all my learned
Yeah.
friends who worked very hard to put
Yeah, I very often use the stylus.
almost 20 or perhaps 25,000 pages. And due to my error, they had to do it twice. So they have, I must thank them for the effort they've put in to get these compilations.
I can blame it on the laptop. You can give it to me so time doesn't rely. In the meantime, they'll find out.
Solicitor, you can give till they find it. You can give. Lordship is saying you give till they find it on that.
Got it.
Page 742. Page 742 and of the PDF pages. You punch in 742.
Not 742.
742.
That's upar karna na.
Yes, 738.
Yeah, correct.
Chief Justice wants to make sure I am doing it by the time I demit office.
No, my learned brother has been a real sport. He's yesterday he spent the whole evening on this.
On the lighter side, I was telling him the only thing in this is that you don't have the pleasure of throwing the file down.
We'll have to go to the volume. Miss Karthik, which volume is this?
Lord, I was wanting to read 738, para 21.
This would be volume 2.
Sorry?
Volume 2.
Volume 1.
No, my lord.
Volume 1
of the precedents. Precedents.
Precedent.
Precedents.
Number 6.
Because it runs into some 20, whatever, 1,000 pages, right?
And what is the para number?
Lord, para 21, the heading is gender identity and sexual orientation.
Got it.
Lord, page 465 of the report.
21.
Justice Bhatt gets it.
Yes, yes. Please go on.
I'll start. Gender identity is one of the most fundamental aspects of life, which refer to a person's intrinsic sense of being male, female, or transgender or transsexual. This case was concerned not with transgenders or transsexual. A person's sex is usually assigned at birth, but a relatively small group of people may be born with bodies which incorporate both certain aspects of both male and female. Then it goes on. Your Lordship sees the last line of that para. Gender identity therefore refers to an individual's self-identification as a man, woman, transgender, or any other identified category. Sexual orientation refers to individuals enduring physical, romantic, emotional attraction to another person. Sexual orientation includes transgender and gender variant with heavy sexual orientation, and their sexual may or may not change during or after gender transmission, which also includes homosexuals, bisexuals, heterosexuals, asexuals. Gender identity and sexual orientation, as already indicated, are different concepts. Each person self-defined is sexual orientation and gender identity integral to their personality and is one of the most basic aspects of self-determination, dignity, freedom, and no one will be forced to undergo a medical procedure, etc., etc., etc. So the importance is not each person's self-defined sexual orientation, gender identity is integral to their personality, one of the most basic aspects of self-determination, dignity, and freedom. This is now translated in Puttu Swami, my lord, as a part of Article 21. This itself. Then your lordship sees.
Page 760.
My lord, page 760.
487 of the.
Page?
Page 760, my lord, of the compilation. 487 of the report.
760, yes.
Para 61.
Yes.
This is on Article 14. If your lordship sees last 4 lines of para 61, 61 does not restrict the word person and application only to male or females. Hijras, transgenders who are neither male female fall within the expression person and hence entitled to legal protection of laws in all spheres of activity, including employment, healthcare, education, as equal, etc., etc. Would your lordship just see the first part also? Yes, I should have read. Article 14 states that state shall not deny to any person equality before the law or equal protection. Equality includes full and equal enjoyment of all rights and freedoms. Right to equality has been declared as a basic feature of the Constitution, and treatment of equals as unequals and equals as unequal will be violated. So, equality in the preamble, equality as reflected in Article 14, is also, my lord, a basic structure, just like secularism, just like judicial review, just like rule of law, and some other aspects. My lord, last line of that page, discrimination on the ground of sexual orientation or gender identity therefore impairs equality before law and equal protection of laws and violates 14. Your lordship turns to the next page. Para 63. Article 15 and 16 prohibit discrimination against any citizen on certain enumerated grounds, including ground of sex. In fact, both articles prohibit all forms of gender bias and gender-based discrimination. 15 states, state will not discriminate against any citizen on the ground of sex, etc. Then come to 66, my lord. 15 and 16 sought to prohibit discrimination on the basis of sex, recognizing that sex determination is a historical fact and needs to be addressed. Constitution makers can be gathered, gave emphasis to fundamental rights against sex discrimination so as to prevent the direct or indirect attitude. This is important. So as to treat the direct or indirect attitude to treat people differently for the reason of not being in conformity with the stereotypical generalization of binary genders. Both gender and biological attributes constitute distinct components of sex. Biological characteristics, of course, include genitals, chromosomes, secondary sexual features, but gender attributes includes one's self-image, deep psychological or emotional sense of sexual identity and character. The discrimination on the ground of sex under 1516 therefore includes discrimination on the ground of gender identity. The expression sex is not limited to biological sex of male or female, but intended to include people who consider themselves to be neither male nor female. This then found its way, my lord, in Anuj Garg, that, my lord, employees of a hotel, whether you could, this find, my lord, mentioned in Anuj Garg. No, but the same thing is in Anuj Garg. Same thing is in Anuj Garg. Though Anuj Garg was earlier. Justice Sinha speaking for the court. Same thing is in Anuj Garg. And what your lordships have, my lord, discounted is the view of Nargesh Mirza. My lord, next page. Second line. State is bound to take some affirmative action for their advancement so that injustice done to them for centuries could be remedied, etc. Then, my lord, 19(1)(a), para 69, just above placetum E. Article 19(1)(a) states that all citizens will have the right to freedom of speech expression, which includes one's right to expression of his self-identified gender. The self-identified gender can be expressed through dress, words, actions, or behaviors. So expression is not limited to, my lord, speaking, speech, or reading. The self through dress, words, actions, no restriction can be placed on one's personal appearance or choice of dressing, subject to restrictions contained in 19.2. My lord, the next page, 763, page 490 of the report, para 71. The principles referred to above clearly indicate that freedom of expression guaranteed in 19(1)(a) includes freedom to express one's chosen gender identity through varied ways and means by way of expression, speech, mannerism, clothing. Gender identity, therefore, this is important, lies at the core of one's personal identity. Gender expression and presentation, therefore, will have to be protected. Under 19(1)(a), a transgender personality could be expressed by his behavior and presentation. The state cannot prohibit, restrict, or interfere with the transgender's expression, etc., etc. Then, my lord, para 73, Article 21. After the quotation, Article 21 is the heart and soul. The Constitution which speaks of the right to life and liberty. Right to life is the most fundamental, not even the state has the authority to violate. Article 21 takes care of aspects of life which go to make life meaningful, protects the dignity of human life, one's personal autonomy, one's right of privacy. These are prophetic words which ultimately came about in Puttaswamy. Right to dignity is recognized as an essential part of the right to life and accrues. Francis Corali Mullin, this court held the right to dignity forms an essential part, and my lord, is not only mere existence, that your lordship said, that then 74. Recognition of one's gender identity lies at the heart of fundamental right to dignity. Again now Article 21. Gender is already indicated constitutes the core of one's self-being as well as an integral part of an identity. Legal recognition of the gender is therefore a part of the right to dignity and freedom. Again, my lord, re-emphasizing Article 21. And then 21, my lord, his lordships talk about Anuj Garg, etc. My lord, para 82 on the next page is the same, but I don't wish to read it. That's all. Now we go to Puttaswamy. Puttaswamy, my lord, in the same volume,
Page 63.
at page, starts at page 63 of the compilation. Your lordship sees, my lord, the opinion of his lordship Justice Chandrachud, as his lordship then was, at page 407 of the compilation, 345 of the report. Your lordship will find, if your lordships get that, if all my lords have it, my lord.
Yes. Just 1 second.
My lord, 407 of the compilation, 345 of the report.
What para is it?
My lords get it?
What para is it, I said?
My lord, it starts at 407, page 345 of the report.
Page starts at page.
I want to go straight to the expounding of the preamble at 464 of the compilation and 402 of the report.
Yes.
Para is 105. Para 105. 106 is Sajjan Singh. Now see 107. Keshav Nanda, Sikri CJ noticed that the preamble is a part of the constitution because there was a debate on this. Is it a part? Is it a preface? Etc. etc. The preamble emphasizes the need to secure to all citizens justice, liberty, equality, freedom. Together they constitute the founding faith or the blueprint of values embodied with a sense of permanence in the constitutional document. Preamble speaks of securing liberty of thought, expression, belief, faith, worship. Fraternity to be promoted to assure the dignity of the individual. Individual is at the core of the focus ideals of justice, liberty, equality. Animate the vision of securing a dignified existence. So, my lord, actually, if you read the preamble and these 2-3 paragraphs, Article 14, 15, 16, 19, and 21 all will form, my lord, all will form a part of one whole.
Four 498.
Your Lordships have, my Lord, referred to the preamble. And as I said, my Lord, in the opening, all the phrases in the preamble are significant because they appear in their avatars as 14, 15, 16, 19, and 21. That's the importance. Equality, justice, fraternity, liberty of thought, expression, all these forms, my Lord, is in 14, 15, 16, 19, and 21. Now, my Lord, your Lordship talk about jurisprudence on dignity in para 108. 108. This is on dignity and the importance of dignity. Third line, the constitutional vision seeks the realization of justice, liberty of so and so, so and so, equality as a guarantee against arbitrary treatment, and fraternity, which is, my Lord, dignity. Then para 110, Francis Corali Mullen, where your Lordship said mere existence is not life. That, my Lord, is reflected in paras 7 and 8 of Francis on the next page. Bandhua Mukti Morcha, to the same effect. What is life? What is dignity? Then, my Lord, para 119 at 468. To live is to live with dignity. This is very important. Dignity and life must coexist. One without the other is no good. The draftsmen of the Constitution defined their vision in society, which constitutional values will be attained by emphasizing, amongst other freedoms, liberty and dignity. So fundamental is dignity that it permeates the core of the rights guaranteed to the individual. Part 3. Dignity is the core which unites the fundamental rights, because the fundamental rights seek to achieve for every individual dignity of existence, privacy with the attendant values, assuring dignity and due. Only then life can be enjoyed with dignity, can liberty be of true substance. So if you don't have full enjoyment of life, you will not have, my Lord, full dignity. Yes. Then, my Lord, paragraph 144, it's marked here, at page 483 of the report. This is very important, my Lord, for the majoritarian group within the society and the minority group. Para 144 is critical, my Lord, for my purposes. Neither of the above reasons also. That a minuscule fraction of the country's population constitutes LGBT, as observed, is not a sustainable basis to deny the right to privacy. The purpose of elevating certain rights to the stature of guaranteed fundamental rights is to insulate their exercise from the disdain of the majorities. This is what is happening to us. We are facing this disdain. We are facing this stigma. Whether legislative or popular, the guarantee of constitutional rights does not depend on their exercise being favorable regarded by majoritarian opinion. The test of popular acceptance does not furnish a valid basis to disregard rights which are conferred with the sanctity of constitutional protection. Discrete and insular minorities face grave dangers of discrimination for the simple reason that their views, beliefs, or way of life does not accord to the mainstream. I respectfully submit, Milad, this is the core of my argument. Because we are minuscule, because we have faced this over the years, because we have been sidetracked, because we are looked at with disdain, because we are looked at with, my Lord, unpopular feelings, because we are looked as squares. That's why the word queer. You are different, you are queer. And you were subjected to 377. You are no good. You are no good. That's how it was. That no good, my Lord, is removed substantially by 377. But what about the stigma in place? As my Lord Menka said, what about the stigma which is going on? In workplace, here, there, pension, we are facing that stigma. That can only be removed by a constitutional declaration by the highest court of the land. That my rights are equal to those of the others. They have a right of marriage, unit of family, respectability, plus a concomitant of rights which flow from that respectability. The same thing should accord to me. And I should not be discriminated only because, my Lord, we may be 10,000 and the others may be 10 crores. This is the core, my Lord, of my submission. Then, my Lord, next page. Last line, Lord, of that page. I have to read this paragraph. Yet in a democratic constitution founded on the rule of law, their rights as sacred as those conferred on other citizens to protect their freedoms and liberties. Pausing here, Milord, it is argued on the other side. We are not equal. As if we are back in the 30s or 20s or 1800s, that you are lesser mortals. So don't talk about rights. Don't talk about marriage. Live the way you are. Be happy that 377 is gone and be done with it. That, Milord, is the approach of the majority, which is being reflected by the other side. Sexual orientation is an essential attribute of privacy. Discrimination against an individual on the basis of sexual orientation is deeply offensive to the dignity and self-worth of the individual. Equality demands that sexual orientation of each individual society must be protected on an even platform. Very important, the phrase is even platform, not an uneven platform of equals and unequals. The right to privacy and protection of sexual orientation lies at the core of fundamental rights of 14, 15, and 21. There can be no doubt now, my lord, that my rights, which will ultimately now, this will be followed by Navtej. So reading this and Navtej will make it clear that the rights of all, including my clients, in full exercise and enjoyment of their rights in 14, 15, 16, 19, and 21, must be the same as that of the others. And therefore, the next logical step after removing 377 is the cherished object of marriage, family, and a unit in the society's order. And that, my lord, will give us other rights which we are talking about, whether larger issues, smaller issues, but those, my lord, will give us. But it gives us respectability. It's not only a case of, all right, no 377, but you live the way you want. Live the way you want in your house. Don't come outside. Because if you come outside, the majority will look at you with disdain. That has to be removed, my lord. And when your lordships do it, it has the same effect of law as Parliament by virtue of Article 141. And it is no answer ever to tell, my lord, a constitutional court, which is the guarantor of fundamental rights. My lord, last 70 years it has been said that this court is the guarantor of fundamental rights. It is no answer to say that even if one man comes and complains of his violation, my lord, of fundamental rights or an enforcement of fundamental rights, you better wait for Parliament. No answer. No court has, this court has never accepted that answer. 32 is itself a fundamental right. I have a right to come to the court and complain. My fundamental right is being violated, not followed, not being implemented. And this court must come to my aid. Need not be a group. Maybe the whole, my lord, the population may be against me, but I have that right. And I cannot be told, with great respect, I submit, my lord, in humility, that I must wait for Parliament. Somebody should then enact after I am dead and gone. Then, my lord, 145. When your lordship, my lord, reverse Kaushal, last 4 lines, my lord, of 145. The rights are not so called, but are real rights founded on sound constitutional doctrine. They inhere in the right to life. Again, 21. They dwell in privacy and dignity. Now a part of 21, my lord. They constitute the essence of liberty and freedom. Sexual orientation is an essential component of identity. Equal protection demands protection of identity. So real rights, that people should not look at me with disdain. People should not say you are queer. People should not say let's not be friends with you. Then, Milad, that is Kaushal. Milad, 146. The decision in Kaushal presents a de minimis rationale when it asserts that they have only 200 prosecutions. This is an argument of minuscule against the majority. Kaushal went on this, Milad. So very small people, very small group. How does it matter? Why should it bother? The de minimis hypothesis is misplaced because the invasion of a fundamental right is not rendered tolerable when few are opposed to large number of people. This is the minority versus the majoritarian rule. No steamrolling. No steamrolling of ideas, faiths of one major group over, my lord, a small. Otherwise, my lord, look at religion. It will lead to religious persecutions. Suppose in a country, my lord, the majority is of one religion, and you have small other religions. If you go by majority, you will steamroll the other religions. The moment you do that, you lose being secular. You lose, my lord, being plural. So our constitution has guarded against it. Be diverse, yet be Indian. Be whatever religion you have, but you are an Indian. Whatever faith you profess, whatever language you speak, no matter your card or your creed or your caste or your place of birth, the constitution intends to raise all this, my lord, from the times of 1800s and the deprived to today to be a forward-looking, my lord, community. Then, my lord, in para 147, your lordship leave the issue of my lord, Navtej. Now, my lord, kindly come straight to page 558. Para starts, my lord, at 294. Then, my lord, it talks about, my lord, violation of law, fundamental rights. See, my lord, 297. Essential nature of privacy. Essential nature of privacy. Second line of that para.
Just one
Yes.
second.
The ability.
One second.
195.
559 at the foot is para 297. Yes. Without second line, placidum G. The concept is founded on the autonomy of the individual. The ability of an individual to make choices lies at the core of human personality. Choice, notion of privacy enables the individual to assert and control the human element, which is inseparable from personality of the individual. The inviolable nature of human personality is manifested in the ability to make decisions on matters intimate to human life. These words echo today. Choice, my lord, of human lives, choice of people. It's not, my lord, an elitist concept. It is, my lord, innate, with which people are born. So was Nero born, and thousands of years ago. Autonomy of the individual is associated over matters.
On Nero.
Sorry, my lord.
Let's not model ourselves. Sure.
You're right, my lord. You're perfectly
Last
right.
thing.
We can't model ourselves on Nero.
Of all the
Nero said this when Rome is.
There are enough examples.
He was saying that
We
when
can't-
Rome was burning.
Let's say we can't fiddle.
Yeah. Then, my lord, between placidum A and B at page 560 of the report, without the ability to make choices, the inviolability of the personality will be in doubt. One line later. Privacy is a postulate of human dignity. Thoughts and behavioral patterns which are intimate to individuals entitled to a zone of privacy where one is free of societal expectations. In that zone, an individual is not judged by others. Privacy enables each individual to take crucial decisions which find expression in human personality. It enables individuals to preserve their belief, thought, expression, ideology, preferences, choices against, please mark, my lord, very critical, against societal demands of homogeneity. So no steamrolling. Privacy is an intrinsic recognition of heterogeneity or the right of the individual to be different and to stand against the tide of conformity in creating a zone of solitude. Privacy protects the individual from the searching glare of publicity in matters which are personal. Privacy attaches the person not to the place where it is. Privacy constitutes foundation of all liberty because in privacy, an individual can decide how liberty is best exercised, etc., etc. So this is the tide of the majority. which is stigmatizing me, my lord. Today it can't criminalize me because of a lordship judgment. It can't criminalize me like Mr. Thomas was criminalized, my lord, in America. When the police came and knocked on the door, it was a police raid. They found, my lord, he was indulging in that act. And he was charged by University of that law of Texas. I can't be criminalized, but the stigmatization continues. My lord, last 10 lines of that page in para 298. The autonomy of the individual is the ability to make decisions on vital matters of concern to life. Privacy has not been couched as an independent fundamental right, but that does not detract from the constitutional protection afforded to it. Once the true nature of privacy in relation with those fundamental rights which are expressly protected and understood. Privacy lies across the spectrum. The guarantee of equality is a guarantee against arbitrary action. It prevents the state from discriminating between individuals. The destruction by the state of a sanctified personal space, whether the body or mind, is violated the guarantee against arbitrary action. Privacy of the body ties individual to the integrity of the physical aspects of it. The intersection between one's mental and integrity and privacy entitled the individual to freedom of thought, freedom to believe in what is right, what is wrong, etc., etc. My lord, just between placetums B and C, the freedom under 19 can be fulfilled where the individual is entitled to decide upon his or her preferences. Read in conjunction with 21, liberty enables the individual to have a choice of preferences, etc., etc. Sorry, Milord, I missed one line. See the third line on top. Family, marriage, procreation, and sexual orientation are a part of dignity, and dignity is a part of 21. So what I am requesting your lordship to grant me a declaration is a declaration of my right under 21. That's what I am respectfully submitting. And procreation in, my lord, today's scenario can also include adoption, IVF, surrogacy. Need not only be procreation in one form.
I think family comprehends it.
Yes. Then, my lord, again, I have read that lesson. Now, my lord, 299, first line. Privacy represents the core of human personality. So, privacy, dignity to lead a full life, full enjoyment, sits in Article 21. And therefore, my lord, my request to the court is a declaration of my right under 21, read with 19 and the troika of 14, 15, and 16. Then, my lord, page 569 is the conclusions. Where MP Sharma Millet is overruled at 316. Your Lordship would recall, my Lord, MP Sharma was 8 judges. That is why it was sent to 9. And when before 5 it was argued, my Lord, I was on the other side. I showed, my Lord, MP Sharma to 5 judges. And then 5 judges had to send it to 9 because
I was at that time arguing before 3-judge bench, a
That's
defamation case. And I was arguing privacy is an integral part. So as Attorney General, he came to me and said, Sima, I argued there is no privacy. What are you doing here?
So, my lord, I showed from MP Sharma, there is a direct line that there is no concept of privacy in the Constitution. That's what MP Sharma said.
That is why you got it referred.
That's why, my lord, it was referred to. But by that time, my lord, I had left that side and come to this side.
As I was reading all these paragraphs, I was remembering what you were arguing and how so fondly you were reading paragraph after paragraph, which is what I was arguing there before Deepak Mishra.
Mr. Attorney General, your predecessor ensured that the privacy reference ensured that the Aadhaar decision was substantially delayed, you see. So the stack to ensure कि
and my lord Khadak Singh, etc. My lord, see para 321, page 570. This is critical for another reason, and I want to read this. Judicial recognition of the existence of a constitutional right to privacy is not an exercise in the nature of amending the constitution, nor is the court embarking on a constitutional function of that nature which is entrusted to parliament. It applies on all fours to my case. So this is one paragraph.
321.
321, my lord, is very critical for my purposes to counter the argument. Let us wait for parliament to do something, and the court should, my lord, keep its hand off. That, my lord, is answered in 321, applies on all fours. And this is the judgment, my lord, of 9 judges, squarely binding, my lord, on this bench. And the same thing, my lord, I will show from Justice Nariman's view in Shairaban. Same thing. But that this is 9 judges, my lord. That's the import of this case. 321 is directly binding me. Privacy postulates a bundle of entitlements and interests which lie at the foundation of order and liberty. Below 323 is very important again. Again on plurality and the majority. 323 below. Para. Privacy includes at its core the preservation of personal intimacies, sanctity of family, marriage, life, marriage, procreation. Please underline marriage. These are prophetic to my case today. I am arguing a case of family.
It's slightly more perhaps because it is not only 21. This is in the context of expounding 21. You want to exercise freedom of association.
Yes.
Now, whom do you want to? What do you want to speak?
Yes.
What you speak here and what you speak at home is going to be different. So there's an intersection of privacy in the exercise of every right.
19.
Autonomy
Article
and
19.
privacy go hand in hand along with the exercise of every right.
Yes.
And not just 21 rights.
I appreciate. My right is bolstered by aspects of 19 which your lordship are expounding. But see this blood. Sanctity of family, life, marriage, procreation, home and sexual orientation. What else am I wanting? It is already granted. That's why I said, blood, I'm not reinventing the wheel. It's all here. I'm only putting it together. Because there was no question of marriage in those cases. But I'm only putting it together. Really speaking. So privacy, my lord, is found in this judgment, not only in one article. It is found on terms of, it is found in 21 finds dignity, privacy and dignity go together. It is found in 19(1)(a). Also, my lord, C, associations. That may be another concept of associations, not the original concept of forming an association, like a society or this, that. Associations, right to form an association between individuals, between groups.
No. Exercise of freedom of association itself may involve
yes
the choice, exercise the right to privacy, because what you do in an association.
Yes, of course.
You may not want everyone else to know what you're doing.
Yes, absolutely. Then 326. 326. Privacy has both positive and negative content. The negative content restrains the state from committing intrusion upon the life and personal liberty. The positive content imposes an obligation on the state to take measures to protect the privacy. I'm wanting, my lord, a positive content from them. You want, frame the law. But if you don't frame the law for marriage, the court will set in, and the court's order will be, my lord, a protection, an affirmative protection of my right.
Just to, as an
that in 1954. In 1954, there was no constitutional declaration of what I'm wanting, just as there was no declaration of the Constitution for dignity. So if I get the declaration at the top level, then the statutory level under the Constitution, Lord, is subservient, Lord, level. This must give way and, Lord, adapt itself to the head. If this is the sun, this is something else. This must accord with the sun. Very easy to defeat my rights. Otherwise, you defeat my right by saying, I won't give you a constitutional declaration, even if you are entitled to, because a statute, when made in 1954, was not in accord. It has to fall in accord. So there is no gainsaying that look at the act. Obviously, the act will never contemplated in 1954. We also know that. Therefore, I am not wanting, my lord, merely an amendment to the act without the declaration. Because if your lordship only interpret, my lord, the act, tomorrow it can be amended by parliament. Then we are sunk. So I want first, or I request, not want, I request a constitutional declaration of marriage akin to that of the heterogeneous group. Once I get the declaration, then, my lord, the law which is in existence in 1954 must fall in place with that declaration by a method of purposive interpretation. That's how, my lord, this I have done that. Now, my lord, we go to one para, my lord, of Justice Nariman. Yes. That, my lord, your lordship will find
369, no? Para 369.
Sorry?
Para 369.
No, my lord, 400 and
420.
Which one? What do you want to show? Case law, both in the US and India, show this concept has traveled far from the mere right to be let alone, to recognition of a large number of privacy interests, which apart from privacy of one's home and protection from unreasonable searches, has been extended to protecting an individual's right in making vital personal choices, such as the right to abort, the right of same-sex couples, including the right to marry, procreation, contraception, general family relationships, etc., etc. So clearly, my lord, recognized by 9 judges that the right of choice includes the right to make a vital choice, as far as we are concerned, of a marriage of same-sex couple, and not only to be told that you may live together, but no more. That cannot be said, my lord, as is being argued. Then, my lord, a passage from Justice Call's verdict at 697. What is it?
697.
Can you keep giving us a PDF number?
697.
Can you give us PDF numbers actually? It's easier for us then.
728.
728. 28.
Keep giving us PDF.
PDA. All right. 640, para 647, my lord.
Yes.
Starts with saying, my lord, two aspects of the opinion of Justice Chandrachud, and which is common to the opinion of Justice Nariman, need specific mention, while the evolution of constitutional jurisprudence right to privacy referred to Suresh Kaushal, etc. Now, my lord, see the last 5-6 lines of that paragraph on that page. The sexual orientation, even within the four walls of the house, became an aspect of debate. I am in agreement with the views of Dr. Chandrachud, who in para so and so states that the right of privacy cannot be denied even if there is a minuscule fraction of the population which is affected. Majoritarian concept does not apply to constitutional rights, and courts are often called upon to take what is categorized as a non-majoritarian view in the checks and balances of power envisaged in the Constitution. So this is a reiteration of my lord.
You might turn over the page.
My lord.
Where this caller has quoted from Mosley.
Yes.
Page 69, 698, Paro 130.
Yeah, Mosley, yes. So the David versus Goliath concept will not allow steamrolling. The observation made in Mosley in a broader concept may be usefully referred to. It is not simply a matter of personal privacy versus the public interest. The modern perception is that there is public interest in respecting personal privacy. It is thus a question of taking into account conflicting public interest considerations, evaluating them according to increasing well-recognized criteria. When the courts identify an infringement of a person's Article 8 rights, particularly in the context of freedom to conduct his sex life, personal relations as he wishes, it is the right to afford remedy and to vindicate that right. The only permitted exception is where there is countervailing public interest, which is to say circumstances strong enough to outweigh it. So what is important is, pausing here for a minute, right to afford a remedy and vindicate that right. I am wanting, Lord, vindication of my right. Then, Lord, this goes on. Now, Lord, after this, we go to Navtej.
So, Mr. Rohatgi, there are two corresponding rights and perhaps duties and obligations as well. On the one hand, the LGBTQ community has, or a same-sex couple is entitled to say, I have a right to make my own choices. We have our right to make our own choices, to live as we wish together. And therefore, that is a part of our dignity, our privacy.
Yes.
But equally, society can't say that, well, all right, we will recognize that right and we'll leave you alone.
Correct.
And we'll not recognize your
No
relationship.
more. And which means, my lord, the inequality must continue. We will get married. We will be the main people will look up to. But you are those, you just stay where you are, minus 377, and people will not look up to you.
So we will deprive you of the benefit
My lord.
of conventional social institutions.
Yes, which we have as the majority, but you won't get it.
It's not enough really in terms of privacy to leave them alone.
Yes.
And to make their choices. But to assert a right equally to have the recognition of those social institutions.
So
which
you
give
are,
value
then you are at par. Then only you will be at par. Then the even, not even platform is the phrase used by Lord Chief Justice Chandrachud. How will it be even platform? Even platform means, my lord.
It's not an equality. What Chief Justice is emphasizing is the corresponding duty on the state to
Yes. It's not good enough to say, my lord, leave you alone, minus 377, be happy. I'm putting it very...
Because, each of us, I said that in that part of the judgment where, in a sense, privacy is an individual concept, which allows you to get to the core of your being and to live your life as you want.
Your choice.
But equally, each of us are social individuals, social animals, so to speak. And therefore, for society to assert that, all right, we'll leave you alone, or the state will leave you alone.
But stay where you are.
We will not, exactly. We will deny you a recognition of those social relationships.
That's right.
Which go to the fulfillment of life. That, according to you, is impermissible.
Absolutely. Otherwise, there will be no one homogeneous unity in a nation, my lord.
There's a positive obligation which is cast on the state.
My lord, take reservations. Why were reservations introduced? There was inequality. For various reasons, rich, poor, caste, creed. State gave, my lord, affirmative action to bring them up. That's why, my lord, to bring them up so as to be at par. Because you were left behind for thousands of years. Bring them up with some reservations and then come on par. Still debate, my lord, between reservations and Go to Navtej. Navtej, my lord, is at, what is this PDF page? PDF is 813, my lord. No? 814.
814.
Lord, I am Justice Deepak Mishra, Chief Justice, my lord, the first opinion.
Which page?
Kindly see paragraph 1, my lord.
855. 855 is where
73 running, 814 PDF.
Yes.
55.
So it has to be. It
Are you referring to?
below the first para.
Oh.
After the
Just
index.
1 second.
Paragraph. Not for nothing. Not for nothing. The great German thinker, John Goethe, had said, I am what I am, so take me as I am. Very prophetic. That's what I am saying. And similarly, so and so. Then John Stuart Mill. But society has now fairly got the better of individuality. And the danger which threatens the human race is not the excess, but the Lord, para 2 also. Second line. Denial of self-expression is inviting death. Little, I mean, a bit much, but my lord, that's the import of that phrase. But my lord, turn to the next page. See para 4. And I submit, my lord, the same thing is happening even today, despite 377 having gone. The overarching ideals of individual autonomy and liberty, equality for all, sans discrimination of any kind, recognition of identity with dignity, and privacy of human being constitute the cardinal four corners of our monumental constitution, forming the concrete substratum of our fundamental rights that has eluded certain sections of our society who are still living in the bondage of dogmatic social norms, prejudiced notions, rigid stereotypes, parochial mindset, and bigoted perceptions. Same thing continues. The only difference is, my lord, 377 is gone. So now, my lord, see Placida me, the first step on the long path. So this first step, my lord, business is by two judges. One here and one later. Yes. Well, the Chief Justice wrote very long sentences. What you will find sometimes rather difficult, my lord, in several judgments. Sentences are very, very long.
The lighter side sharing that your late father used to write the reverse. He had the Lord Denning style of writing very crisp sentences and
Small, yes.
small.
Short, yes. That's it. Very short.
Sentence per idea.
So that's the first path, my lord. See, my lord, the last three lines above para 5. We have to be ready to the perceptions, stereotypes, and prejudices deeply ingrained in the societal mindsets so as to usher inclusivity in all spheres and empower all citizens without any kind of alienation and discrimination. Non-acceptance by any societal norm or notion, punishment by law on some obsolete idea. That is the 377 business. Then, my lord, we go straight to paras 96 and 97. And, my lord, page 880 of the compilation and page 98 of the report. PDF 910.
880.
My lord, PDF 910, para 96.
Page 880.
Yes, Lord. The rights that are guaranteed as fundamental rights in our constitution are dynamic and timeless rights of liberty.
Para?
96.
Para 96.
Yes. This is page 8. Yes.
The rights that are guaranteed as fundamental rights in our constitution are dynamic and timeless rights of liberty and equality. It will be against the principles of the constitution to give them a static interpretation without recognizing their transformative and evolving nature. Then para 97. Constitution fosters and strengthens the spirit of equality, envisions a society where every person enjoys equal rights, which enable him to grow, realize his or his potential. This guarantee of recognition of individuality runs through the entire length of the dynamic instrument. Constitution is conceived and designed in the manner which acknowledges change is inevitable, etc., etc. And then, my lord, one para, kindly turn to, my lord, page 888 of the compilation. Para 127. This is again, my lord, minuscule part vis-a-vis the majority. That's para 127. The society as a whole, or even a minuscule part, may aspire and prefer different things. They are perfectly competent to have freedom to be different, like different things, so on and so forth, provided that their different tastes, liking remain within the legal framework. Neither will statute nor results in the abridgment of fundamental rights also. 128. It is the concept of constitutional morality which strives and urges the organs to a state to maintain a heterogeneous fiber in society, not just in the limited sense, but in multifarious ways. It is the responsibility of all three organs to cover any propensity or proclivity of popular sentiment or majoritarianism. Any attempt to push or shove a homogeneous, uniform, consistent, and a standardized philosophy throughout the society will violate constitutional morality. So again, my lord, no steamrolling. The lordship may then turn, my lord, to
Page 1, para 134 at page 8.
144, my lord.
134 also.
134.
134. 134. In the garb of social morality, the members of the LGBT community must not be outlawed or given a stepbrotherly treatment or malefactor by society. If this happens, or such treatment of LGBT is allowed to persist in the constitutional courts and the obligation to protect from it would be failing the discharge of the duty. A failure to do so will reduce the citizen to a side. So, my lord, whether it is section 377, quae the LGBT, or a fulfillment, my lord, of their rights to what we are requesting, if we are not provided that, my lord, then our citizenry, according to this judgment, will be reduced to a cipher.
The duty of the constitutional courts is to adjudge the validity.
Para 131 also, all right, my lord. One para earlier. 4 lines on that para. The court will adjudge the validity on well-established principles, etc. Para 144. Dignity. It's on dignity. Last 4 lines of para 144. Essence of dignity, and we say without inhibition. That is our constitutional duty to allow individual to behave and conduct himself or herself as she desires, to allow him to express himself with the consent of the other. That is the right to choose without fear. It has to be ingrained as a necessary prerequisite that consent is the real fulcrum, etc. Para 152 is a part, my lord, of that page on the top, sexual orientation. Again on choice. If your lordship sees, my lord, page 895, above para 153, on the top, Placitum A. The third one has the proclivity which he maintains does not express in the inclination. The first one is homosexuality, second bisexuality, third heterosexuality. Third is regarded as natural. The first, by the same standard, is treated as unnatural. When the second exercises choice of homosexuality involves in such act, the same is also not accepted. In sum, the act is treated either in accord with nature or against the order of nature. Then we have 155. From the aforesaid has to be appreciated that homosexuality is something that is based on sense of identity. It is the reflection of a sense of emotion, expression of eagerness to establish intimacy. It is just as much ingrained, inherent, and innate, not merely an elitist concept. As heterosexual, sexual orientation as a concept fundamentally implies a pattern of sexual attraction. It is a natural phenomenon as other natural biology. When the science of sexuality is led to it, the individual has a tendency to feel sexually attracted towards the same sex, for the decision is one that is controlled by neurological and biological factors. So not acquired. It's not an acquired feeling or an acquired thing. That is why the natural instinct, which is innate and constitutes the core of identity, that apart on occasion due to sense of mutuality, two adults may agree to express themselves in a different sexual behavior, which may include both the genders. To this, one can attribute a bisexual orientation, which does not follow the rigidity, but allows room for flexibility. 167. Paragraph 167. This is being relied upon, my lord, by the other side, completely out of context. But let's read this, 167. The above authorities capture the essence of right of privacy. There can be no doubt that an individual has the right to a union under Article 21. When we say union, we do not mean the union of marriage, though marriage is a union. So it can be things other than marriage. Yes. As a concept, union also means companionship in every sense of the word, be it physical, mental, sexual, emotional. The LGBT is seeking to realization's basic right to companionship, so long as such a companionship is consensual, free from the vice of deceit, force, does not is the violation of fundamental rights of others.
Just marriage, just one.
Yeah.
What this means is this includes marriage, more than marriage also.
Yeah. Kindly then turn, my lord. Para 255 and 922 of the compilation. This is very, very important.
So 167 is.
Lord, no judgment is read in the Euclid's theorem.
Which para are you referring?
Para 255
Page 922.
and 922 of the paper book.
953 of the PDF page number 9.
This is very, very important.
953 PDF. 922 running.
This is the bedrock of our rights, which are the same as that of the majority or the heterogeneous group. Kindly may not see this. The LGBT community possesses the same human, fundamental, and constitutional rights as other citizens, since these rights inhere in individuals as natural and human rights. We must remember that equality is the edifice in which the entire non-discrimination jurisprudence rests. Respect for individual choice, very sense of liberty, thus criminalizing carnal intercourse is irrational and defensible, manifestly arbitrary. True that principle of choice can never be absolute, etc. However, the organization of intimate relations, the matter of complete personal choice, especially between men, it is a vital personal right falling within the private protective sphere in the realm of individual choice. Such progressive proclivity is rooted in the constitutional structure and is an inextricable part. So it starts by saying, my Lord, organization of intimate relations. And obviously it will include marriage, companionship, partnership, friendship, love, expressions. And the paragraph starts, my Lord, this is the foundation. The LGBT community possesses the same human and other rights. If I have the same human and other rights, then there is no reason why I cannot, my Lord, have the concept of marriage. And not enough to say that you are left alone, so be alone. See, my Lord, 261. 2 pages down. That apart, any display of affection amongst the members of the LGBT towards their partners in public, so long as it does not amount to industry or has the potential to disturb order, cannot be bogged down by majority perception. It's all about majority perceptions, Milad. So now there is no criminalization, but the majority perception persists. That look at them, they are living together. What kind of status do they have? Lord, in the Indian society, every parent wants his child to be settled. One of the aspects of settlement is not only to choose your education and vocation, but is also marriage, family. You settle down. That's not ingrained in our society. Maybe other societies too. May not be in other societies, at least in our society. So we must have it, or we should have it. We request this court to grant it to us. Then we'll add the conclusions here at 926, para 268. We'll see 268.3. Constitution is a living and organic document capable of expansion with changing needs. See 268.4. Primary object of a constitutional democracy is to transform the society progressively. So society must be transformed by law made by parliament or by declaration of law made by this court under Article 141. Similar to 268.5. Constitutional morality embraces within its spheres several virtues, foremost of them being the espousal of a pluralistic and inclusive society. Concept of constitutional morality urges the organs, including judiciary, to preserve heterogeneous nature and to curb any attempt by the majority to usurp the rights and freedoms of a smaller or a minuscule section. 268.6. Right to live with dignity has been recognized as a human right on international front by a number of precedents of this court, and therefore the courts must strive to protect dignity of every. For without right to dignity, every other right will be rendered meaningless. Dignity is the inseparable facet of every individual that invites reciprocating respect from others, etc. The Constitution has laden the judiciary very important duty to protect and ensure the right to the individual, including the right to express and choose without any impediment, so as to enable an individual to realize his full fundamental right to live with dignity. Then, my lord, page para. Para. Then, my lord, one or two passages from Justice Nariman. My lord, your lordship will find para 314 is reference to Anuj Garg, that women employees case. Yes, I'll leave it at that. Your lordship may see only one para here. What para? 354 we could show. 69. Lord, there is reference to Shafeen Jahan and Shakti Vahini. That is the right to choose a partner, but I will show it from another opinion. Those are referred here. Shafeen Jahan and Shakti Vahini, my lord, are judgments of this court that a person has a right to choose a partner for marriage. But I want to show it from another opinion. Your lordship may turn, my lord, to the opinion of Justice Chandrachud commencing at page 352. Sorry. One para 352 and then, my lord, his lordship's opinion. 352 is, my lord, an answer to the fact that you wait for parliament. Para 352. Kindly turn to para 352. This is very important, my lord, to repel that argument. Another argument raised on behalf of the interveners is that change in society, if any, can be reflected by amending laws by the elected representatives. Exactly what is argued today. Leave it to parliament. Very, very important issues is what they say. Thus, it will be open to parliament to carve out an exception. But this court should not indulge in taking upon itself the guardianship of changing societal mores. Such an argument must be emphatically rejected. The very purpose of fundamental rights chapter is to withdraw the subject of liberty of the individual and place such subject beyond the reach of majoritarian government, so that constitutional morality can be applied by the court to give effect to the rights, among others, of discrete and insular minorities. This is taken, Milan, from a US judgment. So idea is to take it away from the right of majority governments, which means parliament, and leave it, Milan, to the courts. One such minority has knocked on the doors of this court, and this court is the custodian of fundamental rights of citizens. These fundamental rights do not depend on the outcome of elections, and it is not left to majoritarian governments to prescribe what shall be the orthodox in the matter concerning social morality. Fundamental rights chapters like the North Star of the universe, constitutional morality always trumps any imposition of a view of social morality by shifting a different majority. A complete answer. This is the province of this court. It is not the province of parliament. Parliament can certainly do it. But this argument can't be raised, leave it to parliament. Because your lordships are the protectors of fundamental rights under part 3. And therefore, if my right is violated or not effected or not given me full play or panoply of my rights, I must come to the court. And the court will grant me. And repel the argument that wait for parliament to act as and when it chooses to act. Because no mandamus lies to parliament. My lord, then 369. is the penultimate paragraph of Justice Nariman. See 367 actually. 367 is to debunk the theory of Kaushal. See, my lord, 367 and 369. 367 debunks Kaushal, that only 200 people are being prosecuted, etc. The Lordship says neither here nor there. Now 369. We may conclude by stating that persons who are homosexual have a fundamental right to live with dignity, which in the larger frame of preamble will assure the cardinal constitutional values of fraternity that has been discussed in Nandini Sundar, Subramanian Swami, etc. Now, my lord, a few passages from the opinion of His Lordship, my lord.
370, the directions of the court. Directions still not Indian Express article.
My lord, just note that in 370, there were directions that they should give full publicity or all media to this judgment. Only to say, my lord, that today's paper says nothing has been done. 5 years have gone by.
GB is not covered.
Nothing.
The allocation of business rules.
They say allocation of business rules do not cover, my lord, LGBT. What is allocation of business rules to do when you have to, my lord, implement an order of this court? This is how, my lord, even there is not even lip service. It's disdain. It's disdain of the court's direction. Now, my lord, kindly turn, my lord, to the opinion of Justice Chandrachud. Your Lordship, my lord, straight away, there are some passages. Kindly turn, my lord, to 406, para 406. Chapter starts with equal love. 407, Article 14 is Fundamental Charter of Equality. Then see, my lord, 418. Difficult to locate any intelligible differentia between indeterminate terms as natural, unnatural. Even more problematic to say classification. Individuals who supposedly engage natural intercourse and those who engage in carnal against the order of nature. But that was not for 377.
Natural way of raising children and
Yeah, that's all right. My lord, then let's go straight to the major ones here. We can't go to so many. Your Lordship will find, my lord, 431. Formalistic interpretation. In fact, my lord, at 430, page 1000 of the report, towards the foot, my lord, is the interpretation in Nargesh Mirza. That is, my lord, on the words, on the ground only of sex, under Article 15. That, my lord, is explained in 431 and 432. And in 432, your lordships will note the divergent note in Anuj Garg. Come straight to this.
Yes.
My lord, paragraph 438. Just above para 438. The view in Nargesh, my lord. So, my lord, Anuj Garg was the test for Article 15, not only on the ground of sex. Anuj Garg is approved, Nargesh is disapproved. That, my lord, is just one line above para 438. That is on Article 15 now. 439, the court records Nargesh is incorrect. And 440, a provision challenged as being ultra vires the provision of discrimination on the ground only of sex is to be assessed not by the object of the state enacting, but by the effect that the provision has on the affected individuals and their fundamental rights. Any ground of discrimination, direct or indirect, founded on a particular understanding, would not be distinguishable from the discrimination which is prohibited by Article 15 on the ground of sex alone. See below the doctrine of effect. What is the impact? What is the impact on us in not being able to marry and say, all right, you live like this, like a live-in couple, as opposed to the heterosexual group. Because live-in couples also have rights now, my lord, under the DV Act. Even that is not given to us. Then, my lord, para 462.
461, Mr.
Or 461. History has been witness to a systematic stigmatization and exclusion of those who do not conform to societal standards or what is expected of them. 377 rests on deep-rooted gender stereotypes. In the quest to assert their liberty, people criminalized by operational provision challenge not only existence but also a gamut of beliefs they strongly rooted majority understand of what is normal. In this quest, the attack on the liberty is a challenge to a long history of social history. Persecution of people based on it. They have been subjugated to a culture of silence, leading their lives in closet. There must come a time when the constitutional guarantee of equality and inclusion will end the decade of discrimination practice based on majoritarian impulse. That time is now. So it was now then, my lord, for 5 years back for 377. I think should be time now for what, my lord, we are expecting as a natural consequence of what happened in the 5 years. Then, my lord, confronting the closet. The right to privacy is intrinsic to liberty, central to human dignity, and the core of autonomy. These values are integral to the right of life in 21. Meaningful life is a life of freedom and self-respect, nurtured in the ability to decide the course of it. In the 9-judge bench, this court conceived the right to privacy as natural, inalienable. The judgment delivered on behalf of 4 judges holds. Privacy is a concomitant of the right of the individual to exercise control of his personality. Finds an origin in the notion there is certain rights natural and inherent. Natural rights are inalienable because they are inseparable from human personality. Human element in life is impossible to conceive without existence of natural life, etc., etc. Then, Milady, if your lordship turns to 464, Puttu Swami rejected the test of popular acceptance, which was found in Kaushal. Then, para 144, Milady, I have read that. Paul concurrence, I have also read, which is on the next page in the middle, where para 647 is read. Now, 465. See third line. This is important. While facially, section 377 only criminalizes certain acts, not relationships. The argument is relationship is not criminalized, you carry on. What is criminalized is now removed. But that is not good enough. It alters the prism through which a member of the LGBT is viewed. Conduct and identity are conflated. The impact of criminalization, non-conforming sexual relation, is that individuals who fall outside the spectrum of the heteronormative sexual identity perceived as criminals. Now, I am not perceived as a criminal, but I am still perceived as a person who is not up to no good, or who is not as good, unworthy of standing shoulder to shoulder in the public arena with the heterogeneous group. 466 also. 466 Milad. World over, sexual minorities have struggled to find acceptance in the heteronormative structure imposed by society. Then Milad, 467. To deny the member of the LGBT community the full expression of the right to sexual orientation, deprive them of entitlement to full citizenship. This is very, very important. I'll read this again. To deny the members of the LGBT community the full expression of the right to sexual orientation is to deprive them of their entitlement to full citizenship under the Constitution. Pause here for a minute, Mira. When you deny me the right of marriage, you deny me, my lord, citizenship. If you deny me citizenship, you are saying you are no good. You are not equal to a citizen under the preamble. So you stay where you are, Mr. So-and-so. No criminalization, no, you won't go to jail, but stay, my lord, in the closet or in the bedroom and do not come out, my lord, hand in hand or ask for this marriage business. That is 467. My lord, 468 also. This is on privacy to incorporate a right to sexual privacy. Inalienable right to privacy must be granted the sanctity of a natural right to protect in the Constitution as a fundamental right and the soulmate of dignity. So privacy, dignity go in hand. Dignity is a part of, my lord, life lived to its fullest under Article 21. Then, my lord, 470, just, my lord, see 4 lines above 472. It must placidum A on that page.
469, P and D.
Yeah, I'll read 460. Citizens of a democracy cannot be compelled to have their lives pushed into obscurity by an oppressive colonial legislation in order to ensure to sexual gender minorities the fulfillment of fundamental right. Imperative to confront the closet is a consequence confront compulsory heterosexuality. Confronting the closet will entail reclaiming markets of all desires identity in acts which is challenged. 229. It will also entail ensuring the individuals belong to sexual minority have the freedom to participate in public life, breaking the invisible barrier that heterosexuality imposes. I am grateful, Madam. This para is important. So this is again steamrolling by the heterosexual over, my lord, this minority. My lord, may I continue for half an hour tomorrow, my lord? And I will. I am grateful, very grateful.